Because the file was, I was not getting the file, so I am testing it. Just in the morning I got it. So
It got misplaced.
My lord?
Your file is misplaced.
No, it has been received, it has located in the morning only. So I have to study it for some time. 2 weeks time will call.
Two more advocates are there for the response number 2.
I have informed.
Mr. A. Where the case for our today we missplit and so it is a 2018 matter. So we'll listing it after, may not be after 1 week, but after 2 weeks.
May I please your lordship? May I please your lordship? One I beg to mention item 28, but some personal difficulty matter. So next second week of June, madam.
28.
Hearing method. Date may be fixed, madam.
Your name is
Anuddin, madam.
Anuddin, I know,
Yes.
but your name is not reflected. In item number 20, you are saying
28, madam.
28. Your name is not anyway. But Mr. Anuddin.
Madam, date may be fixed. So
Date
we
may
can
not
come
be
prepare,
possible.
madam.
It may not be
Then
possible.
18 or 18 if possible, madam. 18 if possible, madam.
It will come after 2 weeks only. It may not be
Madam,
possible. It's not possible. Because already lots of death has been
he is
taken in the month
in
of
jail
June.
madam more than 3 years, madam. So
Huh? He is in custody.
yes, yes.
In custody. 18. Okay, then 18.
18.
May I please your lordship? I beg to mention item number 22. Matter will be listed on next week, lordship.
You are for the petitioner.
Yes.
Students. Instructor. 1. Oh.
Obliged.
May I please your lordship, with prior consent from the opposite party, I beg to mention item number 26. If your lordship permits, I
26. You need an adjournment.
adjournment.
You are for the appellant.
Appeal.
Why you need adjournment?
Yesterday I was suffering from fever, lordship, and now also I am in fever, lordship.
The metric. The brick. Is recording. Oh,
After 2 weeks.
after
Much
May I
obliged.
please your lordship? I beg to mention item number 32. For my personal difficulty, lordship, it will be taken after 2 weeks. Sir.
it's after 3 weeks. It will be listed after 3 weeks.
Alright.
May I please, your lordship? Lordship, I beg to mention item 20, lordship. 20. It's old matter, lordship. Our file is somewhere misplaced, lordship, lord. This matter may be taken after 2 weeks, lordship. In the
So
mean,
it's a old matter. What do you say?
file is misplaced, lordship. You could not test the file, lordship.
Till now you could not
No,
trace out the file.
file, lordship.
Okay, reason maybe.
And we may be allowed to obtain a copy from course copy, lordship. Copy of the petition, lordship.
It's certificate copy. He can apply for. You can apply for certificate copy. That we cannot give you a free copy now at this stage.
Lordship.
You can apply.
Um,
It will be listed after.
May it please your lordship? Lordship, this is a 439 bail application, lordship, second time. In the meantime, lordship, co-accused already released on bail, lordship. The FIR, lordship, will find on page 15, lordship.
Then this matter is connected with item
Item
number
number
7,
seven.
I'm told. 7 case diary is there. But in this matter, it has come up for motion.
Anyway, we can put it.
Lordship.
7 and 1 is the same matter.
Co-accused.
Co-accused. Here, Lordship, FIR on page 15, Lordship. Nothing
Lordship.
named in the FIR, Lordship. These petitioners are not named in the FIR, Lordship. Though case was registered under Lordship section 4.
My lord, I have perused the case diary in connection with item number 7. I have not examined. Let it be taken up after some time, so that I can go through the case diary. What implication is
But
there?
one
against
thing I just want to say, because we are taking the after motion,
Yes.
this motion, we'll take the other bail hearings, because
sir.
one part matter is there in the item number 2.
My-
It may take on that
No,
day,
I
on
need
last
only-
occasion it took around from 10:40 to 4. I heard that matter, so it may take that time. So then, okay then.
After
you
5
take-
minutes,
eh?
my lord. After
Okay,
5
oh, yes, sure, sure. Now we can start the other bail hearing.
There is one more motion matter in supplementary list.
Okay.
Yes, my lord. I am here.
Yes.
But one moment, CD maybe second time, my lord. CD maybe call my father. Just for your lord.
306, sir.
Yes.
Suicide note
Six,
was
but
there.
which I have gone to the
Oh, that.
that my suicide note. This lady is a long graduate. I am just my your kindly see that next time, man. Something will come out, my. One day for Peruvian of the second year.
Anyway, okay, then we calling for the case.
My
then.
lord. The date maybe fixed, my.
This is Morigaon, sir.
Yeah, Lahore.
Or Lahori Ghat. কি নয় এইটো কি জুন 12th of June or anything না কি করব 10th of June
11, man.
11 lordship
Obliged.
Case diary is there. Call.
Item 8, the other side is absent. Yeah. Because the remain absent, that's the council.
8 and 9 because
Was also remain absent in other case. He may have some problem.
Eh?
Mr. Tutia was there in the for the petitioner. Otherwise, we have received the case diary.
sorry. 9. Sorry, my lord. It is not me.
We are on item 8.
My lord, sorry, my lord, case diary is not there. I don't know 8 case diary is there.
Was he in interim? Interim was there, right?
11. It would be 8 to know it is.
He is on interim.
888
He is on
My
interim.
lord, case diary is not there.
Otherwise, he is an interim. I think.
Yes, it.
Interim continue with.
On
I think
7th of June, my lord.
7th of.
Item 9 case diary is there.
May it please your lordship.
9 and 11 are same, my lord. Same
9
case diary.
and
9 and
11.
11.
Lordship, I am appearing for item number 11.
My lord, the matter
Who
may,
is for item number 9?
my lord, I am for item number 9. The matter may kindly pass over for the time being. Senior counsel K.N. Chaudhary sir will move the case.
Just I want to say one thing. One part matter will start.
Yes, lordship.
Then it may not reach also, because it may take whole day. That is,
My lord, he is on interim, my lord.
I am on interim, my lord. I
He
am
is on
already on
interim. Let it be
interim.
day after tomorrow. He is on interim.
Then, Lordship, both these matters may come together tomorrow.
you are for 11.
11. Same matter. Lordship, both the matters may come tomorrow.
Tomorrow we are not. I'm not taking this back. So
Then it is up to
Monday
your
or
lordship.
Tuesday.
Yes,
Monday
yes.
or Tuesday.
Any day, I have no objection.
Okay.
If time permits, the matter may kindly be taken today also,
I
lordship.
cannot say it.
As it matter
It may not.
Pole no
It may not.
Okay, lordship.
because the matter which is part that we are now going to start may take the whole day. Probability is here. I cannot say at this stage. If the argument is short from their side, then it's okay. But otherwise, it may go up to 4 or 4:30.
Monday, Lordship, Monday.
For the
He is
matters,
already immediate.
you are on interim,
My lord.
and you are on.
No.
You are not.
There is no way.
So case diary is available. So let it be on Monday.
Monday.
Let both the matters come
Be tagged together.
Take together.
Yes. We are listing both the matters on Monday or Friday.
Oblige.
Monday. You are on 9. 9 interim
Item number
is
9.
there.
Yes, Lord.
Interim is there.
Interim is there.
9 or interim method, let it become
3rd of June.
CDB retained till next date of listing. And 11, no interim is there. Let it be listed on Monday. CDB. Okay, both the matters.
Oblige, ma'am.
Monday has to be there.
My lord.
Then my lord, case diary is not there.
Case diary you have not received.
Case diary is not. Interim नहीं हुआ.
19.
No.
You are not in
On,
interim.
not in Indian.
On 7th of June.
Under which section case is based on?
Lordship, it's a second application. Lordship.
376, 374 is there.
Oh,
Allegation of
suppose
376.
second application, then obviously has to be there. See the-
376 ingredients is not there, Lordship.
whatever if once
Yes.
rejected,
Yes.
there may not be, I don't know
Right.
at this stage, but CP will be required. So
On 10th of June.
10th of
Can it be a shorter, Lordship?
Manipur
my
election series to where no election counting will be started. All police personnel will be busy.
by 3rd or 4th or 5th,
It will
may
be
not
difficult.
So let it be on 10th only. To remind everyone.
Wait, please, Your Lordship.
Yes, for one.
I am for one, Lordship. Lordship, in this case, FIR Lordship will find on page 15, Lordship. I am for Muqaddul Islam, Lordship.
Page 15.
1-5, Lordship. The case was Lordship raised on the basis of complaint of a police inspector, Lordship, that Lordship, no victim has lost the FIR, Lordship. Moreover, specific allegation against Lordship, 3-person Lordship, Safiqul Islam and Lordship, Qasidul Islam and Guljar Hussain. Safiqul and Qasidul, from them Lordships, fake gold was recovered, Lordship. Then it's supposed to deliver to the Guljar Hussain, Lordship. Now, Lordship, this petitioner Muqaddul Islam, Lordship, there is nothing recovered from this petitioner, Lordship. In forwarding report on page 17, Lordship will find, Lordship, the ground of arrest, Lordship. Initially, case was registered under 120B, 406 and 420 and 34, Lordship. Subsequently, Lordship added section 489B and 489C, Lordship. Now, 489B and 489C will not applicable against this petitioner because nothing was recovered from them, Lordship. And moreover, Lordship, it is a case of recovery of a gold, Lordship, not from this petitioner, Lordship. So, Lordship, in that regard, Lordship, statutory period will be 60 days, Lordship. Now, this petitioner, Lordship, were arrested on 17/3. And today, Lordships, if I am not wrong, Lordship, 75 days today, Lordship. Now, Lordship, in the meantime, Lordship, co-accused bail already granted. That is, Lordship, will find on page 26, Lordship. 489, 90 days. 489B, 90 days.
And how it is 60 days?
From me, nothing was reported.
That's different thing. That is different.
That's why I am submitting.
No, why do you mistake it?
I have not
You know,
mistaken.
offense is not 60
Subsequently
days,
added.
right?
Subsequently added. Lordship order, that is on page 26, Lordship. Now, Cyril Lordship, 75 days Lordship in jail custody. Moreover, Lordship, this petitioner was very sick, Lordship. I have got an instruction, Lordship. He was admitted Dibrugarh Medical College, Lordship.
Actually, what had happened that earlier petition when we prepared the case, the gold were not recovered from his possession. Obviously, it's right. But the question is, as per his instruction or as he led the police, where from one co-accused, the machine was recovered.
Madam.
That is the name.
Now, my lord, so far, my lord, this offence is concerned, my lord. A good number of people are, my lord, involved. There is a racket,
Yes.
and my lord, his name came out from arrest of other persons, other accused persons.
Yes.
They are involved. My lord, he has told, my lord, the name of 10 to 15 persons. This is one aspect. So far, he is concerned, my lord. In this case, nothing can be recovered. That is a different thing. But he is involved in the racket, my lord. And so far, item number 7 is
And that's why he led the police to for recovery of one machine.
Yes.
For those in which the machine most probably the fake currency notes were prepared or
My lord.
whatever.
My lord.
So that is the
So
main.
this is a 90 days offence, my lord. And so I have objection, my lord. And so far, item number 7 is concerned, my lord. Your lordship may kindly see the one mobile phone was, my lord, seized from him. Item number 7. This is Azharul Islam.
I am for item number
He
7.
is not cooperating with the investigating officer. He has not given the password of the mobile
That,
for which he could not, my lord, examine the mobile phone.
That has been declared in your lordship's earlier order of rejection. That from my mobile phone certain photographs were recovered regarding selling certain fake gold items, lordship. Not fake currency. And he is in custody. How he is not cooperating? He is in custody for 47 days.
Yes, obviously. But he is not providing the password. That is the main. But as per the note of the IO,
Without the password, how the photographs can be accessed, lordship? Lordship may kindly see page 26.
page 20.
Page, lordship's earlier order, lordship. That lordship, third para. In this context, Mr. P. Bothagur, learned additional PP has submitted that there are sufficient incriminating materials against the present petitioner, and from the materials against the present petitioner, it can be presumed that he is directly involved with the alleged business of selling of fake gold. And during the investigation, police also recovered some photographs from his mobile phone of various fake gold articles, etc. Without password, how the photographs can be accessed from his mobile phone? IO can say anything, lordship. That he is not giving password, he is not giving this and that. But from this itself, this is lordship has observed from the CD, lordship, that photographs have been recovered, have been accessed from his mobile phone of certain fake gold items. How he can say that the password is not given? Without password, his mobile phone cannot be accessed. So, lordship, his involvement is as far as the fake gold item is concerned. Fake currency, lordship, it is recovered from one co-accused, Nur Muhammad. And after recovery of fake gold from his house, section 49B and 49C were added. And lordship, till yet the police has failed to identify any victim who has been cheated or who was going to be cheated. So I admit that they were, most probably they were thinking of cheating people. But before that, everything has been seized and recovered. Before lordship commission of any offence. So
I think that those two matters were earlier rejected, in fact.
My lord.
So,
Our investigation is
there
still on.
no ground, new ground, no urgent thing is there. One is under 47 days and the other one is
75 days.
75 days. So, but only considering the length of detention, otherwise there is no ground. No ground. No new ground, nothing is there. Their involvement is there.
Yeah.
So, the second subsequent bail application is not within it. In fact, otherwise, only on the tanker detention that may be one of the aspects. Otherwise, yes,
Well,
everything is. In the city, I have already paid and the protocol to Peru at the time.
And lordship, co-accused has been...
Co-accused from Nur Muhammad, from whom the fake currency notes were in fact recovered. That is led by the other accused is on item number 1. he led the police and he informed, as per his information only, to police recovered those machines whereby it is printing or whatever was there. But there's nothing new.
Thing is that these are economic offense.
Yes, okay.
It breaks down the very backbone of the economy of the country. It is much more serious than even murder case. According to my
Lordship, may kindly see item number 1, Lordship, page 26. One co-accused
so I leave to Lordship.
one co-accused has been granted bail by this honorable court after 57 days of detention. On 15/5/2024.
That cannot be a precedent in every
That cannot be a precedent, but
Bail is not a precedent.
At the same from
It
him
depends
also,
on facts and circumstances and materials.
from him also nothing was recovered.
It was granted because his involvement in fake currency most probably was not there.
Yes.
So considering his length of detention
Yes.
only, that was done. But your petitioner is of behind the bar only 47 days.
Yes.
By that time, the IO may file charge.
Lordship, but from us also nothing, no fake currency, no fake gold even recovered. Recovery is not there. And for till now, Lordship, the IO has got sufficient time to interrogate. 47 days, Lordship.
Yes.
On length of detention, Lordship.
My objection will be recorded.
And that part out of the subject from Mr. Max, do you have any information from the IO that the charge sheet may be called, or is there any note from the IO
Yes.
that FSL has received, FSL report is already received, or is there any note that they are going to file the charge sheet within 10-15 days, or is there any note from the IO
In respect of
in respect of filing the charge sheet?
no, that is not there.
It's not.
Because some people are
Yet to
still yet to be. Because some accused persons has revealed some name who are absconding till now.
But it's no new for not
Tomato stone is naked.
No, same.
however, okay, after get it's no problem. Some other coexistence.
75 days.
15:30 March 17:3 17:15 May is accounting.
Tomato April days, no? Tomato April days.
It's a case of it's a Lakhimpur, not Lakhimpur.
Not looking, yes.
Bipuria.
Virpuria, Lakhimpur, not looking.
CGM Lakhimpur.
CGM Lakhimpur not.
Okay, your petitions have been allowed only considering thank you.
Highly of that.
Both the petition, Lordship. Oblige.
My lords, in item 2, they have filed a miss case, which is not listed, for condonation of delay.
Condonation of delay, Lordship, we have filed a petition, Lordship.
It is not listed, my lords.
Even then, Lordship can have a look into my application. I have filed same application has been supplied to them also. Small petition.
No, my lords, I
Regarding the-
have an objection to that, my lords. Because, my lord, after pointing out, they have come with this. And already, my lord, they have explained only that 22 days delay, what I have pointed out, if lordship recalls. But, my lord, the clock of limitation is still running. Because, my lord, technically, with due respect, my lord, technically, without a condonation application, the revision cannot be registered. Though it is registered as IA criminal in yes, my lord, yes. So technically there is no revision today here outside, my lord. So there are delays, my lords, now. 4 years, 3 months, 5 days.
No.
From that point, my lord.
There is a
They
delay
cannot take advantage of this, my lord.
Admittedly, Lordship, there is a delay of 22 days.
No,
in
my
one case, Lordship.
Person.
In one case, within 90 days, we'll have to file the revision petition. But inadvertently, Lordship, something had happened, Lordship. We don't know what happened at that point of time. There is a delay of 22 days in one case. In another case, there is no delay. It is within the stipulated period of time, Lordship. Lordship, let them start, Lordship. Let them call for the IA, Lordship. In the meantime, it will be in the record, Lordship. I'll place a judgment where it will show that no application even is not required, Lordship. This is a related judgment, Lord, 2023 judgment, Lord. I'll place it.
Well, I'll be filing my objections, my lord. I have a right to object, my lord.
See,
This is not the way, my lord. After pointing out, somebody wakes up, though there is a provision for condonation, this cannot be exercised in a routine manner. Section 3 is there, it's strict, but Section 5 is more strict than that. You cannot come in a casual manner to cover up your lacuna after pointing out. And the limitation Section 9, my lord, it's still running because till today, my lord, technically, my lord, how it being registered, that was the reason I was pointing out. I was surprised, my lord, how this revision is registered. It itself calls for a... So
Lordship,
till today it's there, my
I'm
lord.
placing a judgment, Lordship.
Anyway, the matter was filed and it was registered and running. So now we have to go by the limitation since
Yes,
the
yes.
date of filing only. Otherwise, because it is already rightly or wrongly, whatever,
My lord.
maybe wrong in,
Well, in that case, well, I'll be let these IA come on record, my lord, I'll be filing my objection, my lord. There are certain law points, my lord. This is not the way this can be condoned, my lord.
Lordship, I'm
Because-
placing a judgment where it says, Lordship, no application at all is required. This is a judgment, Lordship. Latest judgment, Lordship.
I also have a latest judgment, my lord, of April. কোনটো judgment is wrong, sir?
Lordship may kindly come to head note, Lordship D. Next page, Lord. Immediately next page, Lordship.
Sheshnath.
Says no.
2021 Sheshnath.
Limitation Act, Your Lordship. Did your Lordship got it?
Yes.
Filing of application seeking condonation of delay under. Well, it is not mandatory to file an application in writing before relief can be granted under Section 5. Further, had such an application be mandatory, Section 5 would have expressly provided so. However, the court can always insist that an application or an affidavit showing cause for the delay be filed. Lordship, this is what the Supreme Court has said.
The premises we
There
have to
is
look
no
into, my lord.
necessity of filing an application. However, the court can insist. My lord, as because they have pointed out that there is a delay. Admittedly, Lordship, there is a delay, Lordship. I don't know what had happened at that point of time and what is the procedure involved, Lordship. We are required to file an application. We have filed it, Lordship. In the filing section, it should be kept in defective, Lordship. And we ought to have been intimated. And thereafter, we will file the petition for condonation of delay. That has not been done. That is, I don't know, that is an inadvertent mistake, Lordship, on the part of us also, and on the part of the filing also. So that happened, Lordship. And there is, this case law even says, Lordship, no application is required. So how they can say
My
that
lord,
it cannot be registered, Lordship?
my lord, though I want to file objection, which I will file, my lord. My lord, that judgment is 21. My lord, can you have a look at my judgment, my lord? This is of 23. January 31, 23, my lord. Page 10, my lords. Page 10. It is quoted Basavaraj in another verses, my lord. It's paragraph 15. The law on the issue can be summarized, my lord. May I read, my lord? The law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause which means an adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case or found to be not have acted diligently or remain inactive, there cannot be a justified ground to condone the delay. No court will be justified in condoning such a delay, inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by this court in regard to the condonation of delay. In case there was no sufficient cause to prevent a litigant to approach the court on time condoning the delay without its justification, putting any condition whatsoever amounts to passing an order in violation of the statutory provisions, and it tantamounts to showing the utter disregard to the legislation, my lord.
Lordship,
These 4 years, all 4 years, my lord, what prevented them?
Lordship, prevented, which is not within our knowledge at the time of motion also, they have not intimated anything. They have not raised any point with regard to that. Now at the fag end of this admission stage, they are taking a plea that no, there is a delay. There is no time
that
prescribed
point,
in
pilot,
the
I
statute,
was-
Lordship, that it has to be filed within such and such time, Lordship. There is no time limit. Even this judgment has said so, Lordship. No application, it is a complete discretion of this Honorable Court. Provided sufficient cause. We have stated in our petition the cause for why it was delayed, Lordship. There is a delay, admittedly, we are admitting, Lordship. Delay, what is the reason, whether the cause shown by us, CBI, is sufficient cause or not, that has to be decided by this Honorable Court, Lordship.
Well, the sufficient cause, in my humble knowledge, cannot be confined to only the 22 days, my lord. It has to be
No,
till
you
today,
argue.
my lord.
That is the discretion
My lord,
of the
my lord,
court.
I'll file a, let this matter come, my lord. I'm not arguing this matter marriage today, because this is not the way, my lord. Somebody wakes up after I show him, my lord. I ponder, my lord, how can this was registered, my lord?
See, rightly or wrongly, whatever, but the question is that if there is a wrong or mistake, whatever, on the part of the registry or the part of the filing sections
My
also.
lord.
That was not intimated. If it would have been defective on the issue of the delay, that could have been intimated to the other side that there is a delay.
With due respect, my lord,
Not
with due respect, my lord,
That may be one of the no.
no, no,
Because it was not
revision.
intimated.
Well, with due respect, my lord, I was not there to assist this court. Even I have done. My lord, the question is, it has to be the right way. This is a court, my lord. This cannot be the wrong way or right way, my
It's a
lord.
right way, Lordship. It is
Cannot
a
be a-
right way. This judgment has shown.
This
It's a
judgment I have to
right
go
way.
through, my lord. I will go through the premises, I have to check, my
You
lord.
take it. Now you
No,
should
no, no.
see.
It's not possible, humanly possible. He comes to the judgment. Because I have provided him copies also, citations also. He doesn't provide
No,
me.
no, I have not been provided any citation and judgment. Where? When did you submit?
And then, my lord, let this miscase come, my lord. It needs a hearing, my lord.
Let the miscase come now only, Lordship.
No, no,
Let us,
no, no.
We have already filed way back
This is
2-3
not
days ago, Lordship. Let it come. Let the slip be called for, be produced to the. Yes, it can be called for. Let the
Even
argument
then, my
start.
lord, I have a right to object, my lord.
We
I will be
I have served a copy.
I'll filing a written
I have
objection.
served them a copy before filing. They
This
have
is
a
not the way.
right.
This is not the way, my lord.
They have obtained a copy.
No.
We have furnished them a copy, Lordship. 2-3 days ago, Lordship.
They may be, my lord.
Then who prevented you to file an objection? We are not preventing you.
It is not CBI who comes with a petition without registering.
No,
We are
What-
not like
what
that.
registering? It has been
to be,
registered.
no, it has to come on board before the court. It has to be, court has to listen to me. I have a right to object and I'll file my objection. This is not the
File
way.
your objection. Who prevented you?
My lord will take on board. If my lord fixes up at some by slip, it will call, but my lord, I'll be filing my objection. Because this is the
Filing objection, what time you will require? How many days?
Well, I'll take 5 days, maybe.
I'll not be here. It will remain part heard again.
Lordship, we have
We are having
supplied them the
my
copy.
bench from 3rd in Arunachal.
We have supplied them the copy before filing. They ought to have filed the objection. Who prevented them to file?
Who prevented them also filing the condemnation last
No,
4
it has
years?
not come in our knowledge. Therefore, we have not filed.
They have
That
should
is the
have been
reason.
diligent, my lord.
That is the reason.
Notice had been not issued, my lord. There should be a notice. Condemnation, lordship, the procedures, there should be notice.
The notice
be
has been
responded.
issued accordingly,
You are
Lordship.
Lordship has to issue notice
Lordship.
on this IA, my lord.
Those technically will be go now. You are appearing, so no notice may not. But yes, you have the right to file
Yes,
objection.
I have a right.
The question of notice is not required at this stage.
That is
I
up to
don't think so.
lordship.
I don't. Because you are here only.
That part I agree, my lord. That part I give, my lord. That part.
Lordship, it is not necessary. You will have to file an objection petition, Lordship. They can make their oral submission also.
No, my lord.
Oral submission,
Everything-
also, whether they are
no.
not relying this honorable court, that their submission will not be recorded, will not be taken into consideration, whether that is their thinking, whether that is their submission, Lordship. They can orally make their submission. They can orally make their objection, Lordship, to the petition filed by us, Lordship. It is not mandatory that you will have to file an objection, Lordship, to the petition filed by the petitioner, Lordship.
You want to get delayed, I think.
My lord.
You want to get delayed the matter.
I don't want to delay, my lord, but I have a right to object. And since my lord, my freedom is at stake.
We have part heard the matter.
My lord, that
Chief
is
said
there.
council are yet
My lord,
heard.
my lord.
On the matter of limitation, already it was heard, most probably.
Yes, but they
At
have
length.
come with the application, my lord.
At a length.
They have come with the application. It is not me, my lord. I didn't ask for any application. It was them, my
The
lord.
judgment itself, the application is not required. Even after we have filed, not required. It is a complete discretion of this court, whether the delay will
I can
condone or
gather
not.
from what he read out, my lord.
That is
There
up
has
to
to
this
be an
honorable
affidavit
court.
also. The affidavit also, no averment is there, no affidavit is there. Had been there any record, any
What
amendment?
the
I feel
law
it
says,
should have
Lordship?
considered.
The law is very clear. It is a discretionary power, Lordship, up to this honorable court. Whether delay will be condoned or not. So, all thing is that sufficient cause should be shown. Whether the application, whether our prayer says that there are sufficient cause or not, that has to be looked into, Lordship. Their objection is, Lordship, not that tenable in law,
This is not the
Lordship.
manner, my lord. After
Let
point out, my
the
lord,
case proceed. In the meantime, Lordship, let the record be called from. I mean to say the application filed by us be called for from the filing section, Lordship.
Yes, Mr. Agarwal, what do you want to say?
seniors are there, my lord, to guide my lords.
In my case, there is no delay.
There is no delay.
You know, your case is item number?
Three.
Item number?
Three.
3.
In my
But
case,
you are arguing on the point of delay on the last occasion.
Who?
Yeah, he's arguing.
No, I have checked personally also. I don't think there is any delay.
So
Because-
you are saying that in item number 3 there is no delay? But yes, in item number 2...
And we have not argued on part of delay and all.
Yes, Mr. Senior
I have
Counsel,
not
Mr. Agarwal has not argued, but Counsel for Sweat Summon, he endorsed the view expressed by my learned friend that there is a delay, and he has also made submission that there is a delay, and he is
Yes, I
hammering
have
on it.
recorded.
No, madam, that time I can argue other differently. But yes, that is implicit, there is no delay. Of course, we can say it is a second.
So now you are appearing in item number 3. In
Yes, madam, so that's so.
that is the one.
Yes. We are not pressing that argument. We have other argument.
My lord will give me some time because, my lord, this is a criminal revision. If
In item number 2, who were the other counsel?
Mr. Bothaku is there, he's on legs in court, my lord, court 1.
Who is there? You are there, and who are there?
Mahajan, Mr. Mahajan is there.
Yes, ma'am.
You are?
Question number 3 and 4, ma'am.
Mr.
On behalf
Mahajan
of
is there.
Mr. B.K. Mahajan.
3 and 4, no, 2 and 3.
3 and 4 নহয় ন?
2 and 3.
So respond number 3 and 4, sir.
Respond number হয় তই।
Item number 2, my lord.
You are for the item number 2.
Oh, yes.
So the delay is related.
2 and 4, yes.
Mr. Mahajan is there. You are here. And Bothakur is there.
Court number 1.
No, whatever. Bothakur is there in item number 2.
Yes, yes.
Otherwise also, Lordship, these two cases, though law points are similar, facts are different, Lordship. Facts are
But
different.
though facts, but law points are almost
Yes, same.
So
Same.
this is the reason we had together
Yes, yes.
those two matters. I have
Yes.
recorded the
Yes.
argument also in that regard.
Facts
I mean,
still may not have any much of bearing on the law.
Yes,
point.
Yes, yes. That is
Only what I have shown, my lord, that the allegations vis-a-vis public emergency and public safety.
Yes.
that
Only for that purpose I have shown the FIR. Otherwise, my lord, I don't think that my lord, the law actual part is required because otherwise, my lord, I have the paperwork of entire
public
paperwork.
safety and emergency. That two
Only
issues
for
you have
that
discussed
purpose,
already.
I have pointed out to my lord the FIR. What are the allegations basically?
Yes. So will it be possible to hear the item number 3?
Yes,
if
yes.
the councils which have not
Argued here.
raised their argument. If that can be done, but then question is that 2 will again be there and it will remain partner because
Well, my intention is
matters
not
that-
to obstruct or to delay. What would happen, my lord? My rights are at stake. If I fail in this forum, my lord, I don't have a re-appeal option, my lords. So very limited chance I have, my lords.
No, obviously,
Yes.
you will definitely. So now you say whether 3 can be proceeded or it has to be heard together.
Let 3 be completed, Lordship. Let me make my submission, Lordship, or reply to the...
On 3.
On 3, Lordship, let the matter conclude in item
And
number
I
3.
also have a request to both the parties that you just, not the detailed argument, but synopsis can be given.
No,
I have
synopsis
already
I have
note-
prepared.
I have
Synopsis
already prepared. I have already noted down because most of the, I think it is not left out, but still, if its synopsis can be given, then it may
Synopsis
be.
is ready, my lord.
Your synopsis is ready.
I'll be supplying today itself, my lord.
Okay.
Are you filing it?
Who are the counsels for?
No, I
items?
am my lord, on late on the other day, my lord. So let me complete my only 3 judgments I would solve, and then I'll conclude
No,
my
you are on item number 3.
3.
You are on
That is there.
Number 3.
number 3.
Correspondence 7.
Correspondence.
And
I'm May I please your lordship? I am for 5 and 6.
In item number 3.
Item number 3.
So far 2 is concerned, Mr. Mahajan is there, he has made his submission.
Yes. Yes.
Mr.
I am
Mahajan.
there in item number 3 also. On behalf of BK Mahajan.
Yes,
Response number?
you are in item number 2 and 3.
Yes, ma'am.
Both the items you
yes,
were there. And Mr. Mahajan has already made his submission on the law points, whatever. In item number 2, there are connected matters, so I have recorded in that manner only. So now say if item number 3 can be continued, but till then the matter will remain part heard because
It
2
will continue to be part.
will be again for
Because
Lordship, with regard to item number 2, perhaps the counsel of the respondent had already made their argument clear, if I'm not wrong. With regard to item number 2.
Item number 2.
Item number 2.
completed, they have
Completed.
Item number 2, all the
Already
counsels have
yes, argument completed.
argument,
Completed.
but only the limitation point,
left,
whatever
left,
They are
left with the
only
condonation now.
yes. They are only on the point of condonation. Yes, and item number 3.
Required lordship in respect to item number 2, response number 1 lordship. Some submission will
You can only allow
only
time
some
and
time
again.
will require, not too much.
Already made their submission. Now they are saying
No,
some
see,
more
that
submission.
day from since 10:40 to 4, I have 30 matters. So it's not repetition. It should not be repeated because 2-3 law points are there mainly.
Yes.
On that long way, there is an extensive argument from your side. Judgments are also cited in that regard. So should not
Only
be,
5 minutes.
should not be
It will
repeated.
take only 5 minutes lordship.
I don't know. In item number
Item number 2 lordship.
2 will be there only because he is going to file some written objection in regards to the limitation. We may proceed to item number 3 only.
Mary Ju.
Yes, in item number 3 only.
3 only.
There are some.
For the number 3 and 4. Three decisions, my lord,
Okay.
which I have already incorporated in here, but I'll just pinpoint to myself. I'll not take much time because other submissions I have already made.
Yes.
I'll not make any repetition on that.
Okay.
And synopsis has been prepared, my lord.
Very nice.
I do not know how far it will help, my lord, but we have tried our best.
It will definitely help.
No, my lord. Distance to do na. Arre. My lord, yesterday, my lord, well, this decision is not incorporated in the but yesterday I was going through, my lord, I found another decision of the Delhi High Court of 2022 STC Online Delhi 1C5. My lord, here, my lord, actually, what happened, my lord, these points.
You are for respondent number?
Huh?
Respondent number?
3 and 4, my lord.
3 and
3 and 4.
Yes.
My lord, let me see. 2022. 2022. Decision lagi nama di ko na consider. To SCC online Delhi 135. My lord, in this case also similar my lord prayer were raised before the trial court negated, my lord, and thereafter trial court framed the charges. Against this charge, my lord, the my lord accused came in revision. My lord, I am not reading because in the entire other merit of the case was also discussed, and my lord, the accused was discharged. I'll just pinpoint to my lord, if my lord can go to page para 59. Sorry. Page 32, para 59. May I just read 59? In the instant case, the material brought against the petitioner is the audio recording of conversation between the accused Sukhbinder Singh and petitioner.
Yes, it's that.
Recording of conversation between the accused Sukhbinder Singh and petitioner as well as the accused Ketan Saha and the petitioner. As per the petitioner, the alleged illegally intercepted telephonic message, a telephonic recordings contained in the charge sheet and all materials collected on the basis of such alleged illegally intercepted telephonic recordings ought to be set aside at naught. It is the case of the petitioner that it is settled law that if the foundation is removed, the structure falls. one of the foundation is not that public emergency and all that. And that the legal maxim sub lato fundamento gaudio opus is clearly applied in the instant case. It has been vehemently argued by the learned counsel appearing on behalf of the petitioner that the court below has not taken into consideration of the fact that mandatory requirement laid down by law placing the reliance on such audio conversation has not been fulfilled by the investigating authority. It is argued that illegally taking of the following conversation being violation of the right to privacy is not now accepted and reinforced as a fundamental right protected under Article 21 of the Constitution of India by a 9 judges bench of Constitution Bench decision in Puttuswamy. Earlier Constitution Bench decision in MP Sharma and so, which did not consider right to privacy as a fundamental right. It has now been held that Constitution Bench that the right to privacy is protected by the Constitution as an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution of India and as a part of freedom guaranteed by Part 3 of the Constitution of India. Now, my lord, I can skip para 61 because the PUCL has been well quoted. I am not reading, my lord, I have read. Then, my lord, para 62 also, Rule 419 has been quoted. Lord, I am not reading. Now, para 63, as per Rule 419 of the rules framed under Telegraph Act, the order of the Home Secretary granting permission to intercept telephonic conversation is to be forwarded to the review committee within 7 days of passing the order for the purpose of being reviewed by the committee. The court does not find any material on record to establish that any review of the order of the Home Secretary was conducted in compliance with the aforesaid rules framed under the Telegraph Act. Therefore, the court is convinced that the special judge, while passing the impugn order, has totally ignored the provisions of the aforesaid rules. This court is of the view that as per section 5.2, para 64, 5.2 of the Telegraph Act, an order for interception can be issued on either the occurrence of any public emergency or in the interest of public safety as per the law laid down by the Honorable Supreme Court in case of PUCL. After perusal of the records, this court is satisfied that in peculiar facts of the instant case, the mandatory requirement laid down by the law by placing reliance on such audio conversation have not been fulfilled. It is an admitted position that 419A17, which provides for destruction of intercepted message, also adopt the state directions. The court below, while passing the impugn order, has also ignored the certain legal positions and directions of the Honorable Supreme Court. It is also relevant to hear that the directions of this Honorable Supreme Court, which are now reinforced and approved by the Honorable Supreme Court in Puttuswamy, as also the mandatory rule in regard to the illegally intercepted messages, audio conversations pursuant to an order having no sanction of law are permitted, it would lead to manifest arbitrariness and would promote the scant regard to the procedure and fundamental right of the citizens and law laid down by the Honorable Supreme Court. So ultimately, on this count and other count, I am not saying only on this count, he was discharged. That paragraph, penultimate paragraph, para 91. So this question was also taken into consideration, and this was one of the points. It said that it was not complied with, so there was a violation of 5.2, read with Rule 419. ये दे दो तो, ये मैडम दे दो तो. Well, while showing the decision of Hukum Chand, 1976, I have referred to paragraph 18. Well, I will not reiterate, it says that if a thing has to be done in a particular manner, it has to be done in that manner, and it cannot be done in any other manner. And that is also, recently, latestly in Supreme Court, in my paper book, this page 115. Paragraph to I'll be just giving the paragraph. I'll not read the entire.
Page 115.
115 of my this paper book. I'll be coming to it. Para 14. page 127. Further, there is another legal principle which is applicable in the present case. It is that where a power is given to do certain thing in a certain way, the thing must be done in that way or not at all, and that other method of performance are necessarily forbidden. Hence, when a statute requires a particular thing to be done in a particular manner, it must be done in that manner or not at all, and other methods of performance are necessarily forbidden. This court too has adopted this maxim. Actually, in para 18 of Hukum Chand, the same thing has been adopted. I am showing the latest decision of 2023, para 14 of this decision. Then, my lord, another decision at page 98. Para 40, 98. That decision is we not going to next to us in the दोनों डिसीजन कौन सा सेट करा दे दो 98
para 112
98 my lord will directly come to para 46 and 47. My lord, it was basically in connection with the regions to be recorded. Lordship will find at 112, my lord. The position in the United States has been indicated by this court in Hasan Mukherjee in SCC so and so of the judgment. This court held that in the United States the court have always insisted on the recording of regions by administrative authorities in exercise of their powers. It was further held that such recording of regions is required as the courts cannot exercise their duty of review unless they are advised of the considerations underlying the actions under review. This court relied on the decisions of the US court in so and so in support of its decision. Now, we are summarizing the above discussions the court holds. I am not ready. Why the regions are required to be recorded, your lordship will find from A to O. That has been taken note of.
Yes, that's basically why the regions should be recorded by the administrative.
Why regions is required to be recorded? There are various reasons why regions has to be recorded. Because my lord will kindly consider one aspect of the matter. That they must say that there must be public emergency. They must be there by just mere quoting. The words of the statute will not do. And another aspect is very important. My lord, the Home Ministry will not issue the order of their own. CBI has to approach. They have to file an application or they have to make a requisition. These are the materials before us which demands that 5.2 should be invoked and order should be passed to intercept these telephone numbers and all. And on the basis of that, the Home Ministry will act because the satisfaction has to be have to be objective. So it cannot be subjective. So another aspect already highlighted. An argument has been made that the learned trial court, while passing the order dated 28/2/2020, did not consider, the orders which has been passed by the director as well as passed by the Ministry of Home Affairs. My humble submission, this cannot be accepted. Your lordship, in para 12 of the judgment of the trial court, the trial court has very specifically stood what materials he has found in the case diary. Para 12 and 13 he has stated that. And in view of that, it cannot be set aside on that ground. Or otherwise also, the trial court has held that, while going through the entire materials on record, does not find any material to sustain that 5.2 read with Rule 419 capital A has been complied. No, वो दे दो तीनों के कौन सा दे रहा देखो hurriedly only one thing I would like to point out. My lord, এটা দিয়ে কিনি করতো হ্যাঁ বাবা সেইটো দিয়ে না this retention of this will not try to cover everything now and accept the decision which I have given today, my lord. That is not incorporated here. My lord, I'll just take only 5 minutes of my lord. My lord will kindly take the criminal petition.
Criminal petition?
In my case, 312 of 2000. My lord, why I am trying to, my lord, trouble my lord? My lord, what will be the consequences? Let us suppose that, my lord, these, my lord, documents were intercepted in accordance with law and order. Assuming for the timing, my lord, I am giving a case. My lord will kindly come to page 52. I'm sorry, my lord, page 53. My lord, it regards to, my lord, review committee. In clause, in rule 2, my lord, sub-rule 2, my lord, it says about review committee. Constitution is there in sub-rule 16, 17 and 18 and 19, my lord, these three I'll read again, my lord. 17, rule 17, sub-rule 17. The review committee shall meet at least once in 2 months and record its finding whether the direction issued under Rule 1 are in accordance with the provisions of subsection 2 of 5 of the Act. When the review committee is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the directions and orders for destruction of the copies of the intercepted message or class of message. It says that cannot be used at all. Here, my lord, your lordship will find there are no material, whether at all, ministries send the orders to the review committee or not. What transpired in the review committee, whether the review committee has gone through it or not, what order has been passed, nothing has been placed. This is number one. Number two, 18 is important. I'm sorry.
Yes.
18 is very important. Records pertaining to such, my lord, the 18 is independent of 17, my lord. Records pertaining to such directions for interception of the intercepted message shall be destroyed by the relevant competent authority and the authorized security and law enforcement agency every 6 months. My lord, these were recorded on 2018. 2018. Today we are in 2024. Unless these are or likely to be required for functional requirements. My lord, it doesn't say that these materials can be used for evidence. These materials can be used for any other purposes. So otherwise they have to destroy within 6 months. Now, now 19. The service provider shall destroy records pertaining to directions for interception of message within 2 months of the discontinuation of the interception of such messages, and in doing so they will maintain extreme. And here, so far service provider are concerned, like Airtel, Jio and all that, who are directed to intercept, they will destroy in 2 months. So, my submission from 17, 18 and 19 is that it cannot be utilized for the purpose which they are trying to utilize. And your lordship will kindly find the law. It was a pre-independence law at the British time, when the Indian citizens were fighting for their independence. Now, these laws were made at that point of time. 5(2) was there. Public emergency, public safety, and all other criteria and other things were there. And in my humble submission, my lord, this 5.2 is not meant for the criminal cases like PCA Act and all other Indian penal codes to be utilized. And this rule has been recently made in view of the directions contained in the PUCR of judgment in 1997. In fact, in PUCR, some of the paragraphs from 30 to 36 onward, the Supreme Court, till the rule is framed, the Supreme Court says that these are the rules that has to be complied with. So, in my humble submission, the revision petition filed by them does not call for any interference. The order has rightly been passed by the learned trial court, keeping in view the law as laid down by the Apex Court and other high courts. I am grateful to my Lord.
Well done. Respond 7. Well, I don't.
For 7.
For 7. I don't propose to be, my lord, guilty of any repetition of the same thing. Well, 3, 4 and 7, we have the same submission because we fall in the same category. And the written submission which has been submitted today, my lord, that is also on behalf of respondent number 7. So we hope, my lord, that we will have some assistance to the court while deciding the matter. My lord, just one or two things that I just wanted to point out. I would really. My lord, in the revision petition, what your lordship will find that it has been filed under 397-410. Obviously, it is questioning the legality and propriety of the order, the impugn order. Now, if your lordship will look into the contents of that revision petition, not a single, except all statements and grounds that was legally wrong, early in law, nothing specific has been placed before the court, enabling the court to set aside that order. Now, merely because somebody has asked for it, the court will not do it. On the day of passing of the impugn order, whatever material the court had, namely the letter by which the CBI was asked to collect the orders of the Home Ministry, there is nothing else. It's only now, my lord, they have come and said that it was very much there in the case diary and court didn't care to look into it. Now, I think this is a little too much. The judicial orders are presumed to be regularly passed. Unless contrary is shown, merely by making a false statement, you can't get rid of that. It's almost leveling an allegation on the court. Only material they placed as an affidavit of a particular person, which is not much of consequence. It only may show that then orders were passed. The other is the letter from some authority to the CBI. You can collect these materials from them. My lord, at that point of time, court was not concerned whether or not these orders were passed. Court was concerned only one thing, that the contents of those orders, whether and to examine whether these orders comply with the requirements of law. Because the court had to pass this order. What else? Court do. It's not for the court to go to CBI office and hand for a document for you. So I submit, my lord, the revision petition merits dismissal. I'm sorry, my lord. And just one thing I wanted to point out, my lord. Your lordship has gone through the orders under 5.2. They must have noticed the peculiarities of this order. My lord, PUCL case says that it must be addressed to a particular person. Now kindly see that in the counter they have annex those order is addressed to none. It's something like giving a certificate to whom it may concern. Use it the way you want, whoever wants. Well, that will not only destroy the sanctity of Article 21, open, no pick up, do anything that you want to. That's why PUCL may not in paragraph. That decision has been placed already. I'll just read out the sentence, my lord. In PUCL case, in our written submission, we have added that. The order shall require the person to whom it is addressed to intercept in the course of the transmission by means of public communication. Order shall require the person to whom it is addressed. So, issuing an order under 5.2 has to be addressed to somebody. Who is the person responsible? It's not to anyone and everyone. Even a constable in the CBI will be able to use it. Even subsequently, it is reiterated. That is one striking and glaring wrong that has been committed in the orders. Number two, it has no seal. Order doesn't contain a seal. Can you kindly see the date? We are yet to see a Government of India order where the day is kept vacant, others are typed out, and then making it open for anyone to manipulate the document. This is what has been done. No. And in some of the orders, my lord, your lordship will find the order has been passed prospectively. In some of the orders, my lord, your lordship, the content will show date of order is 9/4/2018, and that has been made effective from 6/4. So from 6/4 to 9/4, can there be an order retrospectively passed under 5.2? This
Specific order.
Specific order, my lord, from item number 4, that is,
That page.
I'll give the order. With effect on. One is at page 83. Date of order is 9/4. Last sentence, my lord. Date of commencement is 6/4. Similar orders your lordship will find. There are 1, 2, 3, 4, 5. Page 84, 85, 86. So, my lord, what is transpired? It would transpire, my lord, that some kind of interception was done illegally between 6/4 and 9/4, without the order of the Home Ministry. And it is nothing but a regularization order. My lord, under orders under 5.2, the authority does not regularize an action earlier taken. It only permits somebody to act. So how can it be retrospective? Is the scope, my lord? These things we have said so, my lord, in our submission. Okay. 1972, 19718. Well, I don't want to repeat myself and burden your lordship unnecessarily. We have said so in this our written submission also. Kindly, I would urge upon your lordship to have a very pinpointed look at the order. My lord, it's not one case. Ultimately, otherwise no one will be safe in this society. I will not be able to talk to my family. No one can do anything. Now, merely by, copying the section and putting in an order, you are not fit to do anything. That's why all these rigors, well, normally your lordship will find that this kind of rigors are not put. It's only because it's required to be, people's right to privacy has to be protected. That is the right. It's a foolproof process which the places are right to take. And that has to be respected. One case here, somebody is convicted, somebody is not, it's a smaller thing. But violation of Article 21 in my respectful submission would be much greater consequences for the society and individuals. So that's all for response number 7.
You are for?
I am for, my lord, 5 and 6. Suresh Kumar Agarwala and Sri Pranjal sir.
In item number 3, you are for 5 and 6.
5 and 6. Your lordship, I have already made a synopsis because I don't want to repeat, and my senior brothers, they have already gone through all the judgments. However, I have something to rely upon in this case, which is very peculiar in my.
Before you start your argument, I'll just have a 5 minutes break. I have to take medicine in fact.
No problem. I don't want to repeat the same again because I am also relying on the same judgments. So, however, to recapitulate this thing, I am in summarizing few things in this case. This is my synopsis for 5 and 6. So, to start with, this petition is filed by the CBI to set aside the order dated 28/2/2020 and which has been also exhaustively given by the learned trial court below, appreciating that in that order, appreciating the case diary also, whatever there, the proper permission is not there. Apart from that, we must first see how phones are being tapped in India. So there are two procedures, substantive law, and substantive law always followed by the procedural law. That is given in 419A. And we need to see whether those are followed or not. Prior to that, substantive law, that is a section 5.2. Here it is said with regard to the public emergency and public safety. Does our case fall under the public emergency, public safety, or economic emergency? This is a white-collar offences done in day-to-day business transaction. So there is no question of economic emergency, public safety, or there is any emergency in the state. So it itself, prima facie, it doesn't fall under section 5.2. And even if it is assumed that it is filed under section 5.2 of the Telegraphic Act, then procedural law is mandatory to be followed. It is given in your lordship in my synopsis 419A. 419A. Why procedural law has been made? Procedural law has been made to safeguard the right of the public. Because when there is an invasion of a fundamental right of any public, then procedural law is necessarily have to be followed, which is already given in my paragraph, page number 111.
1
One. This is in the
1
111, page number 111. It's in the Binit Kumar's case. The substantive law as laid down in section 5(2) of the Act must have procedural safeguards for this valuable constitutional right as settled in Mentor on this case versus Union of India. The procedure which deals with the modalities of regulating, restriction or even rejecting the fundamental right falling within the Article 21 of the Constitution of India has to be fair, not foolish, carefully designed to effectuate, not to subvert the substantive right itself. So procedural law has been given to safeguard the misuse of the power of the competent authority. Barring that, you are likely. Again, in the next page, 112, paragraph number 9. As of now, PUCL case is still good because it has already been confirmed by 9 judges. In paragraph number 9, moreover, the view taken by PUCL case was affirmed by the said 9 judges of the bench in K.S. Puttaswamy. So PUCL case were elaborately given with regard to the definition of public safety, public emergency, economic emergency. It has been elaborately given there, and still it holds good, which has been affirmed in this case, and it is also averred in the K.S. Puttaswamy. So I am not going on detail. Now I am coming to the point, Your Lordship. With regard to 490, review committee has to be constituted. All these are there, and these are not for the purpose of evidency. It is given in the 419 itself. It has to be kept for a certain period of time, limited purpose, not used for a evidential purpose. Now, I am coming to the paragraph number 5 of my synopsis. Page 5, paragraph 5 of my synopsis. Here, Your Lordship will find, notwithstanding above, it is important to note that the petitioner / CBI obtained alleged permission to intercept the telephone of alleged respondent, accused person, namely Shwetab Suman, Sri Pratap Das, Sri Ramesh Goenka, Sri Amit Goenka, and Balraj Das. My name is not there. So, admittedly, my voice or my phone is not intercepted. However, I have been made party in this criminal division. In the first application which is filed by the CBI, that is at page number 50, Your Lordship. Page number 50 of my synopsis. This is the first application filed by the CBI, which is also rejected at that point of time. Here there are only 4 persons are arrayed as a party in the application. That is Shwetab Suman, Ramesh Goenka, Sri Pranjal Sharma, and Sri Pratap Das. Admittedly, the telephone of Pranjal Sharma is also not intercepted. I am coming to that, Your Lordship. So this is the first application which is rejected by learned court below. Thereafter, the CBI came to the High Court. They have filed a revision. That is, I am coming to Your Lordship. Revision of this case. Lordship, page number 55. 57 reflects the name of the parties for whom they have filed a revision. Page number 57 in the High Court. First revision. That is Pratap Suman, Ramesh Goenka, Pranjal Sharma and Pratap Das. Only 4% against whom the first application is filed in the lower court. Thereafter, they have again filed the second application, that is at page 59. Here in this second application, all 7 persons are made party, whereas my name is not there in the chart sheet, in the interception of the phone. So I will give the graphs there. So Pratap Suman, Pratap Das, Ramesh Goenka, Amit, Suresh Kumar and Pranjal Sharma, Balraj. This application was again withdrawn. No, while pending this application, second application, the CBI has withdrawn. The date is very important. That is on 7/11/2019. Page number 58. I have already flagged now. Page number 58. It is on 7/11/19, and the second application was filed on 13/10/19. In the next page, second application is to the date of filing. Page number 59. To your Lordship, admittedly, second application was filed on 13/10/19, and the earlier application, that is a revision criminal, was withdrawn on 7/11/19. It is a matter of record. Thereafter, while rejecting this, their application by the learned trial court below, clearly it is mentioned in paragraph number 13, 14, 15, 16 and 17. Shall I go through this paragraph, if your Lordship permit? Page number 67. Page number 67. These are the 5 observations given by the learned trial court below while rejecting the application on the second time, and this is totally based on the case diary of the CBI. Shall I go through this? Paragraph number 13. However, in my considered view, the material that I have perused in the case diary do not indicate as to whether the complete due and proper procedure has been followed with regard to the telephone tapping in this case, in terms of the provision of Section 2 of the Indian Telegraph Act 1885, Rule 419 of the Telegraph Rules and principle laid down in the Supreme Court in this regard. 14. Thus, in fact of this case, on the basis of the material and the view on the above discussion, I come to the considered opinion and finding that the material are not adequate to show as to whether the due procedure with regard to the telephone tapping as required by law has been followed. Secondly, the criteria and the principle of public emergency and interest of public safety required for telephone tapping as laid down in the PUCL case also does not apply in this case. So PUCL case is still hold good. Thereafter many number of cases has come, but the PUCL still hold good, and the learned trial court has relied on this. 15. Consequently, the petition filed by the CBI is unable to pass the test of the telephone conversation. Having been taped in keeping with the due provision of Section 5(2) of the Telegraph Act 1885, requirement of public emergency or interest of public security and the principle laid down in this regard by the Honorable Supreme Court in the above mentioned PUCL. 16. In such situations, since the case of the investigating authority for the voice sample is failing due to invalid telephonic interception, therefore, this court need not go more into the other aspect of the merit of the prosecution case regarding need for such voice sample for ongoing investigation of this case. 17. Therefore, in this context, it is made clear that the petition of CBI is failing on a technical aspect of law as discussed above, rather than the issue of merit of the necessity of the investigating authority for obtaining such voice sample. 18. Accordingly, in the aforesaid facts and circumstances and in the view of the above discussion, the petition 993/2019 filed by the CBI for the voice sample fails and is accordingly dismissed, returned back the case diary. So definitely case diary has thoroughly been perused by the learned trial court. Reasons are not there. So reason for giving the taking of the telephone conversation is also not there. Based on all these factors, as enshrined by the POCL case, that has been rejected. Further, your Lordship will find clarification with regard to case number 74. This clarification is given by the Cabinet Secretary, Press Information Bureau, Government of India, and this clarification is given after the PUCL cases and Hukam Chand. It is already given in the mentioned herein. I am going through, your Lordship. The provision for authorization of interception are contained in section 5(2) of the Indian Telegraphic Act 1825. I am starting with the second paragraph. Read with Rule 419A of the Indian Telegraph Rules 1951 as well as section 69 of the Information Technology Act 2000. Read with Information Technology Directions of Interception of Monitoring of Decryption of Information Rule 2009. The Honorable Supreme Court has upheld the constitutional validity of interception and monitoring under section 5(2) of the Act through its order dated 18/12/96 in writ petition number 225/19, that is PUCL, People's for Civil Liberation, PUCL. So this clarification based on this judgment given by the Supreme Court of India. It has also observed that the right to hold the telephone conversation in the privacy of one's home or office without interference can certainly be claimed right to privacy and accordingly held that the telephone taping would infringe the right to life and right to freedom of speech. Expression enshrined in Article 21 and 19(1)(a) respectively of the Constitution of India unless it is permitted under the procedure established by law. So when there is an intervention of the right to life and liberty, so procedure established by law has required to be followed, and that is not to misuse the authority of the competent authority. Thereafter, the second paragraph, your Lordship, in this regard, the Honorable Court has recalled the observation in the case of Hukam Chand Syamal, Union of India, and other 1976, stating that economic emergency is not one of those matters expressly mentioned in the statute, and further the mere economic emergency may not necessarily amount to public emergency and justify action under section 5(2). So I have already annexed this Hukam Chand's case, page 101. So here, our case doesn't fall under the case of public safety. It is a white collar job done during the day-to-day business. What is economic emergency or public safety? That is when there is a riot or some emergency crop up, and at that point of time, the internet and telephone lines are suspended. It is not intercepted. It is with regard to when at that point of time, it is usually suspended. So our case doesn't fall under this case. Shall I go all the paragraph? I don't think it is required. It is okay. Now I am coming to the charge sheet, your Lordship. Last clarification there. Clarification. I am coming to the last, page 75, last paragraph. Last paragraph, but 7 line, your Lordship. It is clarified that the law does not permit use of telephone taping and monitoring of conversation to merely detect tax evasions. There are specific law and rules that contain the provision for detention of unaccounted wealth and evasion of taxes and interception of telephone without public emergency and public safety being at stake is not in accordance with the law as exhaustively interpreted by the Honorable Supreme Court. The recommendation made by the Cabinet Secretary reiterate the establishment of legal position which should not be seen in terms of conflict between individual or interest group. specific. So this is the in between the day-to-day transaction. So this has been clarified by the Cabinet Secretary after the judgment given by the Honorable Supreme Court on public emergency, economic emergency, and at what point of time the conversations are being kept. Now I am coming to the chart sheet, Your Lordship. Chart sheet, page number 19. Oh, sorry, page number 27, internal page 19, that is of the chart sheet. Page number 27. In my synopsis, page number 26, para 31. Here, Your Honor, permission to intercept the phone of the accused persons. During the investigation, DVDs containing the voice data intercepted by the special unit of CBI Kolkata had been obtained along with the original permission granted by the Union Home Secretary and Director CBI for interception. Mobile number so and so, so and so, so and so. So these are the mobile number. Against the mobile number, names are given, Your Lordship. In the first column, phone number. Second column is name. Ramesh Goenka, Amit Goenka, Shwetab Suman, Pratap Das, and Balraj Daima. In the fourth column, again the phone number is there. Fifth column, name is there. Same Shwetab Suman, Pratap Das, Shwetab Suman, Balraj Daima. Our names are not there. So admittedly, the interceptions are made for these persons only. And voice sample is required for comparison with the voice of these persons only for a steptographic test. So when my voice sample is not there, my voice is not intercepted, why I will compelled to give my voice sample? And why I have been made here party? Yes. I am coming to page number 5 of my synopsis. That is the paragraph 31 of the chart sheet, internal page 18, and here in the synopsis it is 58. During the investigation and the DVD containing the voice data of so and so, these mobile numbers, and page number 6, here I have given the list. Surprisingly, the petitioner oblique CBI has arrayed the respondent number 5, Sri Subresh Kumar Agarwala and Pranjal Sharma as a necessary party in the instant criminal petition, in absence of the transcript and conversation of alleged accused 5 and 6 recorded during investigation. Admittedly, when the petitioner oblique CBI has not recorded any telephonic conversation, transcript of the respondent number 5 and 6, irrespective of the fact, either legally or illegally, as such taking of voice sample for identification of the voice through the use of spectrographic method does not arise at all. The voice sample is a method through which the recording of the voice is taken from the accused for the purpose of comparing the other recorded speech. So my recorded speech is not available with the CBI. In absence of transcript of conversation, taking of voice sample is only a futile exercise and harassment to the accused person, not to speak about the abuse of process of law. The respondent number 5 and 6 are unnecessarily being dragged in this criminal petition. Therefore, the instant criminal petition is not maintainable as against 5 and 6, Sri Suresh Kumar Agarwala and Pranjal Sharma, respectively. My name is not there, and during the course of investigation, even if it is assumed they have either legally or illegally recorded the conversation, my conversation is not there, neither my telephone number is there. Further, if I will come to the permission granted by the competent authority, that is at page number 37. that is at page number 37. There are as many as 13 numbers of permission. I have matched this all the permission and the telephone number. The page 37 contain the permission in respect of Ramesh Goenka. Page number 38, this is also pertain to Ramesh Goenka. Page number 39 pertain to Amit Goenka. Page number 40 again contain to Shwetab Suman. Page number 41, that is for Pratap Das. Page number 42, Pratap Das. Page number 43, Shwetab Suman. Page number 42, Balraj Daima. Then page number 45, Shwetab Suman. Page 46, Pratap Das. Page 47, Pratap Das. Page 48, Pratap Suman. Page 49, Balraj Daima. These are the permissions, whether legally or illegally obtained. As of now, I am not on that. Even if the competent authority has granted any permission, whether it is following by procedure or not, but my name is not there, my telephone number is not there, and admittedly they have not intercepted me. And that is why in the first application of the CBI, I was not made party. And that is why I was not made party in the first application given by CBI for taking the voice sample. That is at page number 50. Only 4 persons are made party. However, Pranjal Sharma name should not appear in this case. That is also wrongly given. His conversation has nowhere recorded. Even in the charge sheet, if we go through the total charge sheet, no whisper at all. In the second application, they have made all 7% party. That is reflected in page 59 of my synopsis. Similarly, on the first criminal revision, that is criminal revision 195/18, only 4 persons are made party, which is reflected at page number 57. But here, in the second this petition, criminal petition, we all are made party. So either by hook or by crook, the CBI is bent upon to book us in the this case. That I have given in my paragraph number 7 and 8. That is, it is further submitted and brought to the notice of the Honorable Court that the petitioner for the first time filed an application before his special judge, Guwahati, on 17/4/18 with a prayer for collecting the voice sample of the accused Sri Shwetab Suman, Ramesh Goenka, Pranjal Sharma, Pratap Das. That has already been narrated. And in the first application, my name was not there, 7 except Pranjal Sharma. That is also wrongly been given, probably, as per our CBI best known why they have arrayed my name. Now my humble submission before your Lordship, that this matter, at least either it has to be dismissed or the CBI may withdraw this application against me for 5 and 6. Since there is no conversation, no tape with regard to my voice, then how they will take my voice sample? No purpose of taking, we are just dragged before this court and even in the trial court below also, we are unnecessarily being dragged. On 7, criminal revision 195/18, in paragraph numbers, page number 7, your Lordship, I have incorporated the order, synopsis, page 7.
Page 7.
Page 7.
Yes.
on 7/11/19, the CBI has withdrawn the earlier application with the averment, and I have reflected this order in view of the submission of the learned counsel for the petitioner that they are not going to pursue the matter anymore. The present revision petition is stand disposed of on withdrawal. So since there is no as such res judicata or criminal estoppel so far enunciated in the criminal law, but they are stopped bringing this petition again in this honorable court. By their own conduct, they are stopped. And I have already relied, whatever the judgment I have already relied, it is given in page number 8, para number 10. From 1 to 6, one is the rule 419, second one is clarification, PUCL and Ritesh Sinha, Hukam Chand, Vinit Kumar. And with regard to the judgment given by the Honorable Supreme Court, Ritesh Sinha, it has dealt only with regard to the power of magistrate, whether the magistrate can give a direction for taking a voice sample, because this point is silent in the section 53. So specifically this power has been elaborated in this Ritesh Sinha case, because legislation was silent to fill up the lacuna till the law is framed. This judgment never speaks that procedural law has to be superseded, and by superseding the Telegraph Act, voice sample can be given. And that is already given in the manner which is the manner if provided there. It has to be followed. It has coming from the Taylor's and Taylor's point time. This rule since been applied exercise the jurisdiction of this court, wherein the basic principle long settled is that the manner of doing a particular act is prescribed under any statute. The act must be done in the manner or not at all. So it has already been coming from Taylor's and Taylor, followed in the Nazir's case also, and thereafter it is followed in the Mekatenoff cases given by the Supreme Court, that is in Chandan Kishore Jha, Chiri Purimani, etc. So my humble submission before your Lordship, this criminal petition has to be dismissed as against 5 and 6.
Made submission, I think. Don't repeat the submission, because if there is anything to say after submission made by Mr. Halloway, it can be clarified. Otherwise, I have already recorded and submission, and then if you want to file any synopsis of the argument, that can be.
Synopsis we will file, Your Worship. I would only like to point out regarding the IA filed by them, Your Lord, for condolence.
For item number 3?
No.
Item number 3, the other
Two,
council
two.
has already...
In item number 2.
Sorry, in item number 2?
Not.
In that regard, most probably the council...
One of the council has
one of
taken-
the council has already raised the matter, and he will file his written objection. So we are now on 3 only.
Lord.
Let us finish the argument for 3, then we'll come to
Lord.
2 after you.
I will not file written objection, Your Lordship. I will only
Only
submit.
submission.
May I please, Your Lordship? For 3, my lord, respondent number 2, my senior has already made his arguments on last date, my lord. All the same judgments relying upon, my lord, PUCL, Kutuswamy and Vinit Kumar, and one more judgment placed, my lord, Shashikant Doshi, my lord, Rajasthan High Court. My senior has only asked me to conduct 2 things again for your lordships, just to refresh my lordships, my lord. Kutuswamy has held that privacy is a constitutional protected right, 2017, my lord. Impugn order is 2020, my lord. As soon as my privacy is a constitutional protected right under Article 21, my lord, I shall not be deprived of my liberty, my lord, only as per procedure established under law, my lord. 419A of the rules, my lord. That is the law. That has not been complied here, my lord. And 419A3, my lord, that they could get the information through any other means. That is not there in the impugn orders, the interception orders, my lord. Because so many PC Act cases are coming up, anti-corruption, ACB takes up, my lord. They recorded on the mobile phones, my lord. They did not go for phone interception, my lord. That has not been done in this case, my lord. On that ground itself, in the Rajasthan High Court case, my lord, Shashikant Joshi, my lord, the orders were quashed, my lord. That is all, my lord. Obliged. Highly obliged.
Yes.
Perhaps all the respondents has made their submission on the point of law, Lordship.
On the point of law.
Yes. Lordship. Now may I
Basically,
make my...
three, 4 points are there.
Yes, yes.
On that regard, the judgments are also there. PUCL,
Yes.
Swami and all.
Yes.
So now, yes.
My
As
reply-
per you, most probably,
now I
the
want to make
materials
my-
were available before the learned court below while passing the order.
Lordship.
Especially the orders passed by the directors or the Home Department or whatever.
Yes.
The order was there.
Order was there.
So that was your submission and rest was submission.
Rest I will make my submission.
Yes.
Your Lordship, the first and foremost thing is that now they are saying that the procedure has not been followed. 419 is the only procedure which is required to be followed while intercepting. Now what is this 419A, Lordship? It has come into play and it was enacted by the legislation only after the pronouncement of the judgment of PUCL, Lordship. The PUCL judgment, Lordship, it has categorically laid down certain procedural safeguards. The moment, Lordship, those procedural safeguard has been enumerated in the judgment, subsequently, Lordship, the legislature has enacted this 419. Now, what is this 419A, Lordship? Your Lordship, you have to understand that. 419A is a procedural, purely it's a procedural law, Lordship. Now, Lordship, in that procedure, Lordship, what has been, power has been given to different government agency, Lordship. Different government agency, the Home Department has been given certain duties to be performed. The CBI or any other law enforcing agency, in order to intercept a telephonic conversation, they were given certain duties. So now, here in this case, Lordship, what we as a CBI, as an investigating authority, what we need to do? We need to obtain an order. Our role is very limited. We need to obtain an order, Lordship. Accordingly, Lordship, let us have a look into the Telegraph Act once again, Lordship, for your Lordship convenient, Lordship. Make it. (419A), Lordship, it is a procedure, it's a completely a procedural law. And any investigating authority, in order to intercept, is required to obtain the order. What rule 419A says, Lordship, may kindly have a look, Lordship. 2, Lordship, rule 1, rule 2. In the Indian Telegraph rules, did your Lordship got it?
Just 400.
In Act, your Lordship will not find it. In Act, your Lordship will not find it. I will provide it. 2, no?
Only.
Sorry. You are on.
That is the rule, Lordship, which was enacted by the legislature. Now, rule 2, Lordship, may kindly have a look. In the Indian Telegraph Rules 1951, after Rule 419, the following rules shall be substantiated, namely, Rule 419, directions for interception of any message or class of message under subsection 2 of the Section 5 of the Indian Telegraph Act shall not be issued except by an order by the Secretary to the Government of India in the Ministry of Home Affairs in the case of Government of India, and by the Secretary to the State Government in charge of the Home Department in the State Government. So, power is vested upon the Home Secretary. In case of Central Government, the Central Government, and in case of State Government, Secretary to the State Government, respective State Government. Now, what as an investigating authority we need to do? We will have to approach the authority, concerned authority, to obtain an order. That is our limited role in this procedure, Lordship. We approach, Lordship, before coming to that, Lordship, in unavoidable circumstances, such order may be made by an officer not below the rank of Joint Secretary to the Government of India, who has been duly authorized by the Union Government Secretary or the State Government, as the case may be, provided that in emergent cases, we are relying in clause 2. in emergent cases, clause 2 Lordship, for operational reason, where obtaining of prior direction for interception of message or class of message is not feasible. So in our case, Lordship will have to see the allegation, Lordship. In this item number 3, CBI received the source information regarding the alleged allegation that the accused public servant, he demanded a huge amount of money, that is 50 lakh rupees, in order to pass a favorable order in favor of the other accused persons who were arraigned in that case. That was the source information. So, on the basis of that source information, we approached the competent authority, and as because it is a telephonic conversation, we got the information that there is a telephonic conversation which has been carried out between these accused persons which are arraigned as an accused. So this, apart from that, we don't have anything from the source. So only on the basis of telephonic conversation, once the conversation is over, we will not be able to get anything. So it is very urgent and emergent condition. It is for the operational reason. We are going to hold a trap. Lordship, as because we are going to hold a trap on the basis of the telephonic conversation, therefore it is a very urgent and emergent situation, Lordship. And accordingly, Lordship, we approach the competent authority. And as because it was not feasible for operational reason, the trap is an operational reason, Lordship. We are holding a trap on the basis of source information. And it is not feasible. The word feasible has been used here in this rule 2, clause 2, Lordship. It is not feasible, Lordship. For urgent and emergent situation, it is not feasible to approach a separate department seeking an order immediately, Lordship. It will take time, Lordship. And therefore, this provision has been inserted. That in emergent situation, Lordship, operational reason, what can be done? The required interception of any message or class of message shall be carried out. Lordship, can you see? Shall be carried out with the prior approval of the head or the second senior most officer of the authorized security, law enforcing agency at the central level, and the officers authorized in this behalf, not below the rank of Inspector General of Police at the state level, but the concerned competent authority shall be informed of the such interception by the approving authority within 3 working days. So, without the prior approval of the competent authority, if the head of the department passes an order, we can intercept, and that has been done in this case, Lordship. There, Lordship, we have annexed certain orders. Lordship, may kindly have a look into the charge sheet for a moment, Lordship. Charge sheet, they have annexed, Lordship. 23-253. Lordship, I am direct.
In your petition?
No, Lordship, in their affidavit, Lordship. They have annexed the charge sheet. I am relying on that charge sheet now. Page number 91 of the charge sheet may be looked into. This is 91, page number 90. What?
Para 31.
Para 30. 91, with your Lordship.
Para 31 of the chart sheet, on page, running page 18.
I am coming to that.
Running page?
18, chart sheet, running page
Let
18.
me, I am making my submission, please don't interfere. Give me a chance to make my submission, please, if you don't mind.
No, in page number 90?
91 of their affidavit, Lordship. 91 of their affidavit.
You are on 31.
I am on 312.
Yes, yes, 91.
Page number 91.
Yes.
Did your Lordship got it? There is a chart down below, Lordship, in para 31. Para 31. Did your Lordship got it? Lordship, in the first page of the affidavit, their name has been shown. It will be very easy for your Lordship to then page number 1 to 22 it was written in the index. Page number 1 to 22.
Their affidavit.
Affidavit. Their affidavit, Lordship. Shwetak Suman, Central Bureau of Investigation Assam, Dr. Shwetak Suman.
Internal page can tell us
The internal page is 18. Did your Lordship got the third sheet, Lordship? Otherwise, I can provide Lordship.
Repeat that.
Yes,
Yes.
Did your Lordship got it?
Yes. Yes.
Page number 91, did your Lordship? Page number 91. Then page number 18. 18, internal page is 18. In the third sheet, internal page
Internal page number
18. 18 down, below it was written here.
Yes, 18.
18. Then Lordship may kindly have a look in para 31. Para 31, this category is stated, permission to intercept the phone of the accused person. So here, during investigation, the DVDs containing the voice data intercepted by Special Unit of CBI Kolkata had been obtained, along with the original permission granted by the Union Home Secretary and Director CBI for interception of mobile number. These are the mobile numbers. There are two bifurcations. Your Lordship, we have made a table, Lordship. In the right hand side, Lordship, permission given by Alok Verma, Director CBI. Did your Lordship got? So this is the initial permission given by the Director as per the procedure prescribed by the Rule 419A. In compliance of Rule 419A, permission was granted to intercept the telephone of Shwetak Suman on 6/4 with regard to telephone number so and so it was written. And on the other hand, just in the left hand side, Lordship, your Lordship will get the phone number of Shwetak Suman, same phone number, Lordship.
Yes.
First it was given on 6/4. This phone number has been ratified as per the terms of this rule 419 as because it's a mandatory provision. They will have to inform the competent authority. It has to be get ratified from the competent authority. So accordingly, this 6/4 intercepted order has been ratified by the competent authority on 9/4. Phone number is same, Lordship. 7599102937. There is no illegality. They are also relying the same points, Lordship. With regard to the other phone number of Shwetak Suman, may kindly look into now. On the other side. So from 6 to 9, 7, 8, 9, within 3 days, the competent authority has accorded the order, approved the order. So we obtained the order and that we have annexed in our additional affidavit. That order has been annexed. It was there in the case diary also at the time of passing of that order. So now the next mobile number, Lordship. Shwetak Suman again on 9/4/2018. On the contrary, Lordship, it was in the next side, Lordship. Same phone number. Shwetak Suman, it has been ratified by the competent authority on 13/4/18. So within 6 working days, it has to be ratified as per this provision, and accordingly it was done. So the order passed by the competent authority is within the periphery of the Rule 14A, 419A law. Similarly, with regard to other accused person, same, Lordship. Initially, it has been intercepted as because there was urgent situation. It is a telephonic conversation, Lordship. It is a telephonic conversation. It is not on the basis of a complaint we are intercepting. It is a telephonic conversation. Source information has been received that there will be a conversation which will reveal that this accused person conspired to pass an order, favorable order, to decrease. What is the allegation, Lordship? It's an income tax department, Lordship. Allegation is that to evade tax. An order has been passed by his subordinate. Appeal has been filed before this accused person in order to pass a favorable order. Favorable order means what, Lordship? Decreasing the tax, and it's a tax, Lordship. Tax is a government revenue, Lordship, which will be utilized for public. It is always public interest is always there, Lordship. Therefore, safety of the public, it is economic safety. Safety doesn't mean only the physical safety, Lordship. It is economic safety of the public, where the tax is trying to be minimized. So therefore, Lordship, the intercepted call has been rightly passed, intercepted with the valid order. Being the investigating authority, Lordship, now what is our role, Lordship? Limited role is to get the order. Thereafter, Lordship, it is the department, other department, Home Secretary, it is their duty to do whatever the rule says. Rule says that you will have to form a review committee. What other provision has been enumerated in Rule 419, Lordship? It is not for us, Lordship. We are quite right and sure that we got the intercepted order for interception from the competent authority. Lordship, while investigating a case, what we are required to do? The petition, secondly, your Lordship will see what was the petition. It is not a writ appeal or writ petition filed by them, Lordship. It is an application filed by CBI seeking the voice sample. They are not challenging the interception order before the trial court. Trial court is not the competent authority. The High Court can look into. So, Lordship, the application is filed by CBI seeking permission to get the voice sample of the accused, which were intercepted by means of valid order. So now, Lordship, what was the stage? Secondly, your Lordship need to see what was the stage when we filed the application. When we filed the application, it is a pre-cognizant stage. The investigation was just very new, Lordship. It is in the nascent stage. Immediately after trapping the accused person, we immediately file an application before the trial court. That is because in order to ascertain the voice sample, the voice intercepted by CBI with the accused who were arrested, in order to confirm that it is the same person whose voice was intercepted, we need the voice sample. It's a very premature stage. Investigation was wrong, Lordship. It is not at the time of framing of charge or after framing of charge. Your Lordship will see what was the stage when we filed that application. It was pre-cognizance stage. Even cognizance was not taken. At that time, what the Learned Special Court has done. Learned Special Court, Lordship may kindly have a look. If tomorrow, in a case, Lordship, if the accused file an application seeking certain document under 207, suppose, in trial court, what is required? Every step is regulated by certain procedures, Lordship. Every step. Police is also required to follow certain procedure to do their duty. It has been regulated by CRPC, Lordship. All procedures are there. It is a procedural law. The police will also required to do. The court is also empowered to follow the procedure during every stage of their trial or before trial. So in this case, suppose in a trial, before trial, trial commences after framing of charge, Lordship. It is before charge. This application has been filed before charge, Lordship. So at that time, if any accused file an application under section 207 for supplying of any document, the document which was seized by CBI, and if the procedures are illegal, whether the trial court will say that no, the procedures are illegal, you are not entitled for the document, whether that can be done, Lordship? No. If an application under section 207 for supplying of any document which was seized by CBI, similar is the case, Lordship. the application we file is to obtain the voice sample, nothing else, Lordship. Regarding the judgment of PUCL, Ritesh Sinha, these are two different things, Lordship. Prior to the pronouncement of judgment of Ritesh Sinha, PUCL judgment was there. The PUCL judgment says that, yes, certain procedural law has to be followed, and these are the procedural law. PUCL judgment then said that if this procedure has not been followed, you are not entitled for the voice sample. Be it PUCL, be it K. Puttaswamy, or whatever judgment they have relied upon. None of the judgments said that you are not entitled for the voice sample. The judgment says that yes, these are the procedures which are required to be followed. If not followed, your right to life and personal liberty are violated, and therefore the interceptions are invalid. It doesn't say, Lordship, that you are not entitled. CBI is not entitled for the voice sample. And Ritesh Sinha's judgment has been passed in compliance, in taking into all the views expressed in PUCL and K. Puttaswamy. Everything has been taken into consideration, Lordship. So therefore, Lordship, this order, these are valid order. Immediately after the interception made by CBI, by the Special Unit Kolkata, Lordship, case has been investigated by CBI Guwahati branch, Lordship. It is a separate branch, Lordship. That interception has been done by Kolkata branch, Lordship. The Kolkata branch, after receiving information, source information, not a complaint or FIR, Lordship, source information, they intercepted with the help of the order, and thereafter, when prima facie the team found that yes, the allegation which were said to us, the information which has been given to us is correct, therefore FIR has been registered. It was directed to register FIR and to investigate the case. And therefore we have investigated. What we did, we made a search and seizure. Initially we made a trap, we arrested the accused person, and thereafter, Lordship, we started taking evidence of all the witnesses and collected material evidence. During that process, Lordship, we have seen certain documents, and those documents are, one of those documents are these orders, which has been kept by the Special Unit CBI. From them we seized, and therefore the CD revealed only those orders. The CD starts from the date of registration of the case. Prior to that it is not, because two different units. Therefore, except that order, other things are not available with us. So, learned court below, while adjudicating upon the application filed by CBI, the finding that there is no material is incorrect. Prima facie satisfaction, it ought to have been that whether there are orders or not. Compliance, non-compliance, they will get, if there is non-compliance, they will get those benefits during trial, Lordship, without examining the witnesses, without giving an opportunity to the central government or the state government, whoever that might be, Lordship. How can the trial court can hold that there is no, no compliance of section 419A, Lordship? It cannot be. The pre-cognizance is a very nascent stage, Lordship. The stage was very nascent. So at that stage, the trial court ought immediately after getting that application, Lordship, ought to have either, as because the special court, power is there of the magistrate as well as the judge also, the session judge also. Dual power is vested upon the court also. So at the time of, initially after registration of FIR, power is vested as a magistrate. An inquiry has been conducted, and during that inquiry, Lordship, prima facie, the court below ought to have looked into those documents and whether the investigating authority required voice sample of the accused person or not. That has to be looked into. However, Lordship, that has not been taken into account. Rather, on the contrary, what the learned court below has did is that no, PUCL judgment has not been followed. The Rule 419 has not been followed. Wherefore, learned court below came to the conclusion that Rule 419 has not been followed, Lordship. Neither the accused are saying that rule, even if they are saying, wherefore they are saying, as because there is no material in the CD. Only on that basis that they are saying that no, there is no non-compliance section 419A. It cannot be, Lordship. Stages will be there. If necessary, they will file an application under the appropriate law to call for those documents. If that is not there, then we'll get the benefit. It is, they have not challenged the legality and validity by way of writ petition before this honorable court, Lordship. They are making a submission now in this our application. Their submission is that they have not followed. Those submissions will not be taken. My respectful submission cannot be taken into consideration at this stage, Lordship. Those are disputed question of fact now. I will say that it has been complied with. Only because of the fact that it is not there in the CD, it cannot be presumed now at this stage. It cannot be presumed that Rule 419 has not been complied with. Lordship, they have relied upon certain judgment, Lordship. Those judgment, all those judgment, your Lordship will find that there is a challenge with regard to the order of the competent authority. All those judgments are a challenge before the High Court with regard to the validity and non-compliance of that. Here in this case, it is not, Lordship. It is our application, Lordship. Lordship will have to take note of that fact. And Lordship, all those judgment, some judgment has been stayed. Vinit Kumar, they are relying upon Vinit Kumar. Vinit Kumar has been stayed, Lordship. Now, the question is whether public emergency or public safety. I have already made my submission that it is public safety because it's an economic offence, Lordship, where tax is going to be evaded by way of passing an order. It's a public money. Government always depend upon those tax to implement the fund, everything, Lordship, for the public safety, for public. And those money has to be tried, made, an attempt has been made by the accused person to take away. That is the difficulty. So therefore, public safety is there, economic safety, and time and again, I have in my rejoinder, Lordship, I have mentioned some judgment, Lordship, where it has been stated, Lordship, I have narrated some judgment. Your Lordship will find it's a case of corruption. It affects the moral fabric of the society. It is well known to your Lordship. Every corruption, every corrupt act, it affects the economy of the country, Lordship. And country, Lordship, it is a democratic form of government, Lordship, where the government has been formed by the people, of the people, and for the people, Lordship. So in a democracy, Lordship, it is always whatever thing has been done, it is for public welfare of the public, Lordship. Now, secondly, I would like to rely upon certain judgment, Lordship. Ritesh Sinha judgment, I will not reiterate, Lordship. It is clear, taking into account all the judgment, K. Puttoswamy, Lordship, the right conferred under Article 21, whether if any voice attempt, I mean to say, call has been intercepted, whether that it is absolute right. It is not an absolute right. The article itself says no person shall be deprived of his right and personal liberty except upon the procedure established by law. So here the procedure established by law is Rule 419. So, in certain public interest, the private person will have to bend down. That has been there written in the judgment of Ritesh Sinha, Lordship. And Lordship, taking into consideration all the judgment, even QCL judgment has been discussed here. And after discussing all those judgments, this rule has been, this judgment has been passed, stating that the judicial magistrate can compel a person to give the voice input before the investigating authority. But I don't want to reiterate that because already this thing has been done, Lordship. Secondly, Lordship, I would like to rely one more judgment. Yes, Now, Sanjay Bhandari, Lordship, we are relying upon Sanjay Bhandari. Sanjay Bhandari, Lordship, it is pending adjudication before the Supreme Court, but it was not stayed. There is no stay order with regard to the finding of High Court. So it is still in force. In para 14 it says, Sanjay Bhandari, Lordship, may kindly have a look. In para 14, Lordship, may kindly have a look. Did your Lordship got it? Para 14. That apart, in view of the above discussion, the first respondent passed the order for detection, prevention, investigation and prosecution of corrupt activities of the petitioner, herein in accordance with the provisions of Section 5.2 of the Indian Telegraph Act. Therefore, this court finds no violation of Section 5.2 of the Telegraph Act, and also it would not amount to violation of right to privacy. So this is the finding. So if we intercept any call, it will not violate the right of privacy. Yes, because, Lordship, now secondly, one more judgment which is quite similar to the fact of the case in hand, Lordship. Yeah. Lordship, there is a latest Supreme Court judgment, High Court judgment. Here in this case, Lordship, the facts are similar to the facts in hand, Lordship. The prosecution, they filed an application before the magistrate. Magistrate allowed to take the voice sample. Being agreed by that order, the accused filed an application before the High Court of Delhi, Lordship. And this is a judgment, Lordship, where it has been held. Facts are completely same, Lordship. Same fact. Voice sample, whether it should be permitted or not. May I read the entire
date?
Oh, yes. Date of judgment is 7/12/2023. Sanjeev Kumar versus State of Government of NCT of Delhi. Here, Lordship, the case of Jitendra Pars has also been discussed, Lordship. May I read the entire judgment? It is very relevant, Lordship. The present petition has been filed from the very beginning. Para 1, you Lordship, see that. The present petition has been filed under Section 482 of the Code of Criminal Procedure, impugn the order dated 1st May 2015, passed by the learned magistrate, whereby the application filed on behalf of the prosecution for taking voice sample of the petitioner has been allowed. And number 2, the order dated 5 May 2017, passed by the learned as ASJ, whereby the appeal review and filed by the petitioner against the aforesaid order of the learned magistrate has been dismissed. Notice in the present matter was issued by the order dated 23 March 2018, passed by the prejudicial bench. While issuing notice, the operation of the order dated 1st May 2015, passed by the learned magistrate, was stayed, and therefore, and the aforesaid stay has been continued till date. Brief facts leading to the filing of the present state below. The present FIR number so and so. Here, only difference is that the act is different. It is the armed act, armed act. This is PCA. In present FIR, under Section 120B of the Indian Penal Code and Section 25, 54, 59 of the Arms Act, was registered against the petitioner on the basis of technical surveillance, whereby the phone of the petitioner was intercepted. On the basis of the aforesaid FIR, the petitioner was arrested along with the other co-accused person. Subsequently, bail was granted to the petitioner. During the proceedings before the trial court, the prosecution moved an application for taking voice sample of the petitioner, which was allowed by the learned magistrate by the impugn order dated 1st May 2015. The appeal filed on behalf of the petitioner against the said order was dismissed by the learned so-and-so. The aforesaid order has been challenged by the petitioner in the present petition. In the status report filed on behalf of the state, it is stated that though a technical surveillance, it came to light that the petitioner had a criminal conspiracy to murder one person named so-and-so. In this regard, the petitioner contacted one so-and-so who was gangster lodged in Central Tihar Jail, at that point of time. The petitioner and so hired some contract killer, including so towards executing the aforesaid conspiracy. 4 accused persons being the persons, petitioners, so were arrested. Subsequently, they were granted bail on it, accused so was killed in an encounter with the so. Lordship may kindly come to para 8. Counsel appearing on behalf of the petitioner has made the following submission. In the present case, technical surveillance carried out by the respondent was not in accordance with the relevant provisions of the Indian Telegraph Act. In this regard, he placed reliance on the judgment of the Supreme Court in PUCL versus Union of India, as well as the judgment of coordinate bench of this court in criminal MC number titled Jitendra Pal Singh, which has been taken note of by the accused, the respondent, Jitendra Pal Singh, versus Central Bureau of Investigation. Counsel for the petitioner further submits that the judgment of the Supreme Court in Ritesh Sinha for state of Uttar Pradesh and so relied by the respondent should be disregarded by this court as the direction passed in the said judgments are in the nature of legislating. Further, the judgment of the Supreme Court in PUCL Supra has not been considered in the following judgment. Par contra, the learned APP appearing on behalf of the state has made the following submission. The prosecution has the power to obtain voice sample of the petitioner for the purpose of investigation. Reliance is placed on the judgment of the Supreme Court in Ritesh Sinha and the judgment of Madhya Pradesh Court in criminal so Julia alias Ulia versus State and others. Para 11. Lordship may kindly come to para 11. It is further submitted that the phone of the petitioner was intercepted in compliance with the provision of Telegraph Act. In this regard, the learned APP has shown to the court a communication dated so from the Office of the Additional Commissioner of Police regarding interception of telephones. Learned APP submits that the aforesaid communication cannot be shared with the petitioner. It is mentioned that telephone numbers of the other persons and hints would violate the privacy of said person. In view of the facts of the intercepted has been done in accordance with the provision of Telegraph Act, the judgment of Supreme Court in PUCL as well as the judgment of court bench in Jitendra Pal Singh are not applicable. It is submitted that no prejudice has been caused to the petitioner if he is asked to give his voice sample, as it would be open for the petitioner to take all objection with regard to legality of the telephone at the stage of trial. So here also the same submission. These things can be taken note of during the period of trial, not at the time of pre-cognizant stage, where investigation is very nascent stage. After hearing the submission of parties, the judgment was reached upon and Learned was directed to file the document showing compliance of type 2 with regard to the interception of the phone of the petitioner in the sealed envelope. Now, Lordship may kindly come to para 26. This is what is the reflection of the request. Would a judicial order compelling a person to give a sample of his voice violates the fundamental right to privacy under Article 21 of is the next question. The issue is interesting and debatable, but not having been. This is the code of Ritesh Sinha, Lordship. Ultimately, Lordship may kindly now come to para 14. Counsel for the petitioner, did your Lordship got it? Para 14. Counsel for the petitioner submits that aforesaid observation of Supreme Court are in the nature of legislation and therefore the same are not binding on this court. He further submits since the aforesaid judgment does not take note of the earlier judgment of Supreme Court in PUCL judgment, the judgment in Ritesh Sinha is par incuriam. So these are the submission of the petitioner. The aforesaid submission made on of the petitioner is liable to be rejected outrightly. It is a settled provision of law that the Supreme Court has the power to lay down guidelines, directions where there is a legislative vacuum till the time the legislature enacts a law. The reliance is placed on the judgment of Supreme Court in Ashwini Kumar, Union of India, and Vishakha and others versus State of Rajasthan. Para 16. In fact, the aforesaid observation of Supreme Court in Ritesh Sinha have been followed by the Supreme Court itself in the order that is so passed in the SFA titled Pravinesh Runupat Chauhan versus State of Gujarat. Relying upon the observation in Ritesh Sinha, the Supreme Court upheld the order of Gujarat High Court as well as special court ordering the accused herein to give the voice sample to facilitate investigation of crime. So para 16 is very important. Learned APP has also correctly placed reliance on the judgment of Madras High Court in Julia alias Ulia Superior whereby the order of message directing the accused person to give the voice sample was upheld. The relevant objection, this is an objection of Madras High Court. Now, Lordship, the power of police officer to take voice sample of a person during investigation is traceable to the definition of what investigation. So, in our case also, it is the duty of the police officer during investigation, it is the stage of investigation, to obtain the voice sample in order to ascertain whether the voice intercepted by the special unit branch of CBI is the voice of this accused person who were arrested or not. Counsel for the petitioner has placed reliance on the judgment of the court-made bench in the Jitendra Singh Pal, where reliance upon the judgment of Supreme Court in PUCL, the court-made bench has quashed the order of trial court framing charge against the petitioner, wherein internally on the ground that calls in that case were not intercepted in accordance with provision of telegraph. So in Jitendra Singh, the stage was different. Stage of the case was different. It is at the stage of framing of charge. In our case, it is not framing of charge. Charge has, as on that frame, not been framed, Lordship. Now, at the outset, it may be stated that Jitendra Pal Singh Supra, the issue with regard to the interceptor call was considered by the trial court at the same of order on charge. The present case is still at the stage of investigation and charges are yet to be framed. Further, in the present case, the learned AP has produced the permission obtained by the prosecution from the competent authority in terms of the section 5.2 of the telegraph to intercept the numbers of accused. So, Lordship, thank you. So, para 19 is the observation that order Jitendra Singh Pal was set aside only because of the fact that it is a state of consideration of charge. In our case, it was not legal to hold that investigating authority has not power to investigate and take the voice sample of the accused. It is different, Lordship. So therefore, the learned trial court has committed an error to hold that the accused person is not entitled to give it because the order, the procedure has not been followed, Lordship. Para 22, Lordship. On the prima facie view, that this court is satisfied that the prosecution has complied with the provision of Telegraph Act and obtained the necessary authorization to the intercept the phone of the petitioner. Therefore, the judgment in the PUCL Supra and Jitendra Pal Singh Supra will not be applicable in the present case. In any event, it would be open for the petitioner to take an objection with regard to the non-compliance of the statutory provision of the interception of the telephonic calls of the petitioner at an appropriate stage or at the time of trial. Therefore, no prejudice has been caused to the petitioner if the petitioner is directed to give the voice sample at this stage. So this is the finding of the learned, this is the Honorable High Court Delhi in this case. The petition, there is no merit in the present petition, the same is dismissed. So, secondly, with regard to the reason, they are saying that there is no reason cited. In all the order, there is no reason cited. For that, Lordship, I am relying upon the judgment of Honorable High Court at Delhi, Santosh Kumar. Elaborate reason is not necessary. What has been held in that judgment huh? 44. Lordship may kindly come to para 44 of that judgment. Para 44. Even though in our orders which were passed by the competent authority, reason has been given that for incitement of offence and for public safety. Reason is there, but elaborate reason was not there, and because it is not necessary as per this ruling, Lordship. There are 44, may kindly have it, Lordship. Did the Lordship got it? There are 44. The disclosure of elaborate reasons for interception order would be against the modified disclosure requirement for the procedural fairness, which have been universally deemed acceptable for the protection of the other facets of the public, including the source of information leading to the detection of crime or other wrongdoing, sensitive intelligence information and other information supplied in confidence for the purpose of government or discharge of certain public functions. Furthermore, the Rule 419 of Telegraph provides for extreme secrecy, utmost care and precautions in the manner of interception as it is affects privacy. So, detailed and elaborate reason is not required, Lordship. The rule itself says that it is for safety, because it will affect it will affect the privacy, Lordship. If we give elaborate reasoning why this order has been passed. So, Lordship, I am summing up my reply, Lordship. One more argument has come that on the last, for the last respondent, they are saying that their telephonic conversation, their phone number has not been entered. There is no order. Lordship, while intercepting the phone call, your Lordship will find two conversations, person of two people from one other, I mean to say the another phone, Lordship. When we verified, when we intercept one phone call, we will get the voice of other person, Lordship. And when we verify that who is the person, concerned person, subsequently during investigation it has come to light that it is this accused person, Lordship. That's phone number. Therefore, we have, in order to ascertain, Lordship, that whether it is correct or not, whether it is this accused person who has communicated with the accused number 1. Therefore, it is necessary, Lordship, to get the.
So their phone calls were also tapped, or no, it's not?
Phone calls were tapped. Intercepted.
But the submission made by the learned counsel is not.
No. Intercepted means intercepted and it was tapped.
In regards to 5 and 6 of the item number 3.
My Lord.
My Lord, may I insist on the thing? My Lord,
I have not completed.
Only on this issue, just clarification. Always there will be two persons. One is the receiving, one is the making the call. So his case is, and our case is, that there was no Mr. Suresh Agarwal on the other side. And his case is he was there. That is a question of fact,
yes,
can be verified.
Yes.
When I sum up, I will assist on this.
Yes. So, therefore, Lordship, we sought for the voice sample of the other accused person subsequently, Lordship, when it has come to our knowledge, after verifying from the department, from this service, I mean, service provider, Lordship, when we verify, when we investigate, and the service provider says that it is the telephone number of so-and-so person, therefore, in order to ascertain, subsequently made the accused in that petition, accuse a party to that petition to give the voice sample, Lordship. Of the Supreme Court with regard to the fact that the magistrate can give such order. It was a simple application filed by CBI to give the voice sample before the court below. That was dismissed, and accordingly we filed a revision petition. During the pendency of the revision petition, it was pending before the High Court revision petition. So that law, the Ritesina judgment has come into play, Lordship. So therefore, Lordship, as because the judgment says that judicial basis is empowered, so therefore we have withdrawn this petition. There is no illegality. The cause of action is different, Lordship. We have stated in that order, it was stated that we are not going to pursue the matter. Pursue the matter with regard to the illegality order passed by Learned Trial Court. Because at that point of time, that law is not there, Lordship. So we are not required to again pursue the matter and come to a finding. Because criminal law cannot give a retrospective effect. We pursue that matter, we cannot say that now that law has come. So it cannot give a retrospective effect. Therefore, we have withdrawn, and because power is vested upon the judicial magistrate now, we applied there, Lordship. There is no, it cannot be said it's a second revision. We have challenged the order, the second order, is a separate issue, Lordship. This order has nothing to do with the first order passed by the Learned Court below. So, Lordship, the submission made by the respondent is not tenable, Lordship. Now, summing up, Lordship, I pray before this Honorable Court that the order passed by the Learned Trial Court is erroneous, it is illegal, and therefore it should be set aside.
Is any clarification for the effect? Okay.
Mr. Srivastava is in another court. One more, on that day I have stated, Lordship.
Oh.
We have one more case. He's in court number 18, I think.
He's in 18 now?
18.
Anyway, he was supposed to clarify some 2-3 points. Mr. Srivastava was supposed to clarify some 2-3 points.
Court number 18.
18, na?
In respect of the matter connected matter, one of the connected.
That is, the issue is different.
No, maybe.
So
But arising out of the same case where in item number 3. Tomorrow the case is fixed for framing of hearing on framing of charges. Now the difficulty is that the matter is, your Lordship is already in session of the matter. Your Lordship is hearing the matter. So once it is decided, whatever may be the result, then if we proceed, it will be always better. I do not know what the trial court will do tomorrow.
It is up to trial court if you file any such kind of petition or if
Lordship
it is
makes some observation.
acceptable by the other side, then charge the hearing on the point of charge may not be
No, we can file an application, but difficult to, because no stay is there from any.
They cannot be.
Huh?
Stay is not there.
I see.
Can file a petition. The matter is pending before this court. But I don't think the charge may be framed.
Charge is a separate chapter, Lordship. It has nothing to do with the
My Lord will kindly consider one of the aspects. Not true. Charge is a different aspect of the matter. Our submission will be that the document which has been already, the voice intercepted, plus the memorandum and other things, and all other related documents, whatever is connected with the voices. If those are...
You can very well submit a petition before you run a special judge.
Yes, Lord.
Maybe consider. Your petition may be considered, I don't know.
No, I'm not saying that. My submission is that if ultimately, if your Lordship comes to a conclusion that whatever order the trial court has passed is correct, then the question arises for consideration that whether those materials can be taken into consideration at all. That is the question.
That I have supplied it. I furnished judgment, Lordship. Santosh Kumar. Santosh Kumar talking about Santosh Kumar, Lordship.
Santosh Kumar.
Yes, Santosh Kumar.
Detailed, elaborate discussion was there, Lordship. By the
that is there. You have submitted the elaborate while passing the order by the competent authority. Elaborate discussion may not be there regarding.
Yes, no. With regard to whether the document which has been seized by CBI, whether those documents can be taken as evidence or not. That is the point which he has raised. If charges were framed, it can be taken as evidence. In this judgment, your Lordship will find.
Now, if you don't have any such kind of clarification, I have already heard all the counsels at length. So I think there will not be any further clarification that has been. Is there any?
Only I would like to make one submission, my Lord. Santosh Kumar, I have not been able to go through it, my Lord, directly, so it's difficult to make some submissions, my Lord. But my friend made one decision in Sanjay Bhandari's case. Sanjay Bhandari case in our written submission we have dealt.
Yes, already.
We have already dealt. So I'm not saying anything. Now two more decisions. One is Sandeep Kumar. My reply to that. SLP is pending, no doubt. SLP is pending. Ultimately, the final authority, Supreme Court, will decide whatever it decides, that will follow ultimately. That is one of the aspects. That is also in Vinit Kumar. SLP matter is pending. In Sanjay Bhandari matter is pending. Another, I think, Rajasthan High Court also is pending probably.
Pending, but stay not.
No, stay is not that. No. Findings are there. Whatever finding given by the High Court. My lord, it's not that has been passed. Findings are there. Until and unless those findings are reversed. One of the judgments are still there. Matter may be have stayed. But I am not saying. And in two matters I have already given the order sheet of the Supreme Court. Matters are fixed on 9/7. Now, so far Sandeep Kumar's case is concerned, it said that the stage of investigation and all that. My submission will be that if it is a illegally intercepted material, whether it is a stage of investigation, whether it is a stage of framing charge, or whether it is a stage of trial, it cannot be taken into consideration at all. Number one. Number two, I today specifically read three clauses, 419A, 17, 18 and 19. 18 is very important because even if it is held to be valid, they have to destroy in 6 months until unless it is required for functional requirement. So that those matters have not been taken into consideration in that decision. So that has to be looked into by my lord, while deciding the matter, because the judgment it may go against me. Sanjay Bhandari is also against me. But your lordship has to take into consideration what material has been taken into consideration.
My lord, with regard to the submission, my lord, with regard to the submission that it is required for functional. What functional, it has not been described. Functional, it can be in the court also. For court functioning also. It has not been described, lordship, not defined. What is the meaning of functional, lordship? So for us, lordship, our submission is that it is required for functional. As because matter is pending before trial court. It is for functional.
No, it is a functional requirement of the authority concerned, not the court, not the that is very specific in clause 18. I have read it, again and again.
That about lordship, one more submission, lordship. Power is vested upon the review committee. Review committee, not upon the judge concerned, lordship, where the application has been filed. So here one more error has been committed. He has exceeded his power, lordship, at that stage, lordship.
The short issue in this case is, I'm just summarizing what my learned brother has said and what we are contesting, is that whether the telegraph can be intercepted, if it can be intercepted, in what manner, and thereafter, if there is any deviation in the manner prescribed, what is the status or what is the outcome? That is the only issue. The power of interception is given under the statute right from the beginning to the state. State means under Article 12 and not to CBI or any other thing. Well, I'm relying on it is the reiteration of earlier orders. So this is the notification issued by the Union Home Ministry Millets, where the 10 agencies of the central government have been empowered to intercept the phones subject to compliance of the due process of law, which is Rule 419, capital A. CBI is at serial number 6, meaning thereby the first import is that interception cannot be done by any other government agency. That means Department of Health or Ministry of Education cannot do the interception. It can only be done by these 10 agencies. CBI is one of them. Millards, at the very beginning, I have said that Vinit Kumari's estate, I am not placing any lines, but it is no longer operating. But Jatinder Pal is operating of the Delhi High Court. And it is against the CBI. So though it is the order of any order of the other High Court may not be binding, but it is binding on them. This court may take a different view because this is also a constitutional court, but they cannot take a different view. They will be in the contempt of the Delhi High Court. So, Millards, the only issue here is that in what manner interception can be done. That is provided elaborately, Millards. It is a, I'm sorry. So, Millards, prior to PUCL judgment, there was no procedure prescribed. In fact, it was a legislative misnomer that without any rules, the state was interfering with the privacy of the citizen. Supreme Court intervened, framed the transit regulations, gave the option to the government to make a rule. Government made a rule. Union of India made the rule. Rule is now there on the statute. So, Millards, Rule 419A of the Indian Telegraph Rules 1951 is the statutory rule. It has to be complied. And my lords know better than me that starting from Nazir Ahmad versus Emperor, King Emperor, to the latest judgment by this Honorable Court as well as n number of judgments by Supreme Court, law is very clear that if a manner is prescribed of doing anything, it has to be done either in that way or not done at all. Now, Millards, with due respect, I am not relying on PUCL because PUCL has run its course. It stands discharged because legislature has in the meantime intervened. So, Millards, now there is a manner prescribed for intercepting the telegraph, which is what is our case. Either you have to comply strictly or you don't have to intercept. That is the general law settled, my lords are aware. So, Millards, the only thing which we have to examine whether they have complied with the law or not. That is the only limited issue before this Honorable Court, Millards, and it is a question of fact. So, Millards, one by one, the 419 is not one stage, it is not a unitary stage provision of law. 419, Millards, before that, I will draw my lord's attention, what is this interception of telegraph about? That is necessary, Millards. Now, two kinds of telephones are available in our country right now. One is which is a landline or fixed line telegraph, and another is what we call mobile phones. Millards, in the case of landline, for interception, a parallel line is given to the agency. That means a cable is drawn, brought to the wherever they want, and they run a, receiving set, and they record it in their recorder. In the case of mobile, it is very tricky now. Why this elaborate procedure is required? That is because of the tricky situation. In the case of, as I said, Millards, if a cable is physically coming from my home to the office of my learned friend, it's a physical existence. It can be verified any time because cable has been laid, provided. In the case of mobile phones, Millards, only a parallel chip is given, SIM, nothing else. A parallel SIM is given to the intercepting agency. They put it in a handset, attach it with the computer and record it and then hear it. Now, Millards, because of this mobile is prone to any kind of manipulation, it is very easy, Millards, to plant anything in mobile handset. That is what the Pegasus was, which matter is pending before the Honorable Supreme Court. If somebody makes a call, let us say from Dubai, on my mobile handset, I pick up. By that picking up, the entire software will be installed or smuggled into my handset, and my handset will start remitting entire data to that number. That is what Pegasus is doing. Millards, I can say, in Government of India, the top dignitaries, like Prime Minister and some other important persons, authorities, they are changing their handset every month. And they are not permitted to retain the earlier handset. Those handsets are to be returned to the government, just to protect the privacy of the I mean, secret communication, let us say the Honorable Chief Justice of India and between the Prime Minister, so that some foreign power is not able to hack it. That is how an Indian security agency hacked the phone of Mr. Imran Khan, the Prime Minister of Pakistan, because he picked up the phone. So, Millets, because of this vulnerability, the legislature in its wisdom has provided an elaborate safeguard, procedural safeguard. It is a 3 stage. One is, Millets, you take the approval of the Home Secretary, either a state or center. You can start interception within 7 days. You have to go to the review committee. What my learned brother is saying, that CBI is not required to go. That is between CBI and the Ministry of Home Affairs. Let them sort out. For me, they are a state. So it is the state which has been bounded by the Parliament that after the approval is given by the Home Secretary, assuming the Home Secretary does not accept the request, its matter is over. But assuming Home Secretary agrees and permits the interception, in that case, Millets, the CBI will start, or any agency out of one of these 10 will start interception. But somebody, whether they or Home Secretary, that is between them, they can sort it out, because law is not specifically provided who will go to the review committee. It says order has to be placed before the review committee. So obviously it is incumbent on them, because sorry. So it is on the beneficiary who is taking the benefit of a provision. It is for him or her to comply with the requirements of law. So it is incumbent on the CBI to get it placed before the review committee. And Millets, if review committee does not approve, within 7 days, it has to be placed before the review committee. If the review committee does not approve, that is 216 and 217 of the rules, it is to be destroyed. Not only interception has to mandatorily, statutorily stop by force of law, whatever has been collected or intercepted, that has to be destroyed. There is a positive command so that there is no question of any misuse or no question of any hacked or planted data by any side. So here is, if the approval is given by the Home Secretary and it is not approved by the review committee, Millets, then on the 7th day, it is stood destroyed, unless they say that they don't follow the law, which of course they are not saying. So I assume it is stood destroyed. Now if it is stood destroyed, there is no data or no evidence available with anybody, including the learned trial court or the investigating agency, comparing which they want this voice sample. That is the first part, Millets. Now, coming to the objections of my learned brother, the judgment which has been cited by him, Millets, especially this Sandeep versus State of NCT of Delhi, para 44. In the case of Sandeep, Millets, Sandeep versus
Two judgments. Santosh is different. Sandeep is a different.
Sandeep, because by Honorable Justice Amit Bansal, Millets.
Sanjeev Kumar, not Sandeep.
Achha, I'm sorry.
Sanjeev Kumar.
Sanjeev Kumar, Millets.
State of Government NCT of Delhi.
Yes, Millets.
Recent judgment also.
So Millets can see para 8.
That arm sect was where the arm sections of arm relied by
In
the
fact,
we have written
judgment is
relied by the
completely-
prosecution.
Sanjeev.
Sanjeev.
Sanjeev Millets. I'm sorry, I recorded Sandeep Kumar. Millets can see para 8. That is the relief being sought by the petitioner in that case, which has been overruled and very correctly. Millets, the first para was that there was no compliance of the requirements of Section 5, Subsection 2. The Honorable Delhi High Court has given a finding that there is a sufficient compliance. Now it is a question of fact. Second plea is that the judgment of the Honorable Supreme Court in the Ritesh Sinha is incorrect law. It is per incurium. Well, per incurium can only by a coordinate bench or by a higher court, not by a subordinate court. Honorable Delhi High Court cannot accept or give a finding that judgment of Supreme Court is per incurium. That is the judicial discipline which courts follow. A trial court cannot say the judgment of the High Court is per incurium. So therefore, Honorable High Court did not accept the second prayer, citing the judicial discipline. Now, the facts in this case are totally different, minutes. In my case, the trial court has returned repeated finding that you have not complied with the requirement of Section 5, Subsection 2 of the Telegraph Act. And it is a question of fact. They have not brought any material before this Honorable Court, at least to our knowledge, on which we could have rendered assistance to this Honorable Court, that Section 5, Subsection 2 has been complied with by them. That has to be shown. It's a question of fact. It's not a question of law on which they can argue, we can argue. It has to be shown how they have taken the compliance. Meaning thereby, Millets, they were required to show to this Honorable Court that, Lordship, I have complied with the first requirement, that is Subsection 2 of Rule 2. Then I have complied with the subsections, Subrule 16 and 17. And thereafter, I have fully satisfied the law. And therefore, the findings given by the learned trial court is incorrect. They are saying it is not my job to take the approval of the review committee. But my liberty cannot be taken away, my privacy cannot be intruded just because you do not know whose job it is. So go back to the state. Tell the state. They will immediately tell you whose job it is. I know the government, how the government functions, Millets. So, Millets, just because they do not know who will forward the order of the Home Secretary to the review committee, can my liberty, can my right to life and liberty under Article 21, as well as under Article 14, as well as Clause 3 of Article 20, be taken away just because they do not know what is to be done by whom? So, my lord, my respectful submission on this issue is that the judgment of the Honorable Delhi High Court in Sanjeev Kumar case is clearly distinguishable on facts. That the requirement of law has not been complied with. That is the requirement of subsection 2 of section 5. The ingredients of that has already been very elaborately stated by my learned colleagues, so I am not going into that. I am saying the requirement to satisfy the twin conditions, either of the two, of public safety and public emergency. They are not even clear under what term they have taken the approval, whether it is public safety or public emergency. There is not a whisper in their revision petition that there was a case of public safety or a public emergency. With respectfully, Millets, as an officer of the court, I do agree that public safety is a very wide term. It will include the safety from corruption also. A citizen has a right to be protected by the state against the corruption. So, protecting the citizen from corruption, in this case the person from whom an alleged bribe is being allegedly demanded, is also the obligation of the state, and it will constitute the public safety. But have you taken the permission under public safety? They don't know. I am 200% sure, Millets, with all the due respect to them, they have no personal thing, they are doing a job, that they may not have written the word public safety or public emergency in their note. No elaborate reasoning is required, conceded. But Millets, at least they will write one line, that in the interest of public safety or in the interest of public emergency, or maybe both, we need to intercept this telegraph, and therefore please permit us. That is why the learned trial court summoned the case diary. And learned trial court has given a positive finding of fact that there is no recital regarding the satisfaction of the requirements. Trial court is not finding them wrong because they have not written 5 pages of the reasoning. Where is this recital that in the interest of public safety or in the interest of public emergency, it is required. So that is my next argument, Millets, that meets his objections. Now, coming to Millets, what is the requirement, Millets? They are saying before this honorable court that investigation is still going on. Millets, I have to rush to the court number 18 of this honorable court to argue another application, in this case for this accused only, since my brother was not available. So court has asked to either it will be taken up tomorrow or if we finish and the court is still available. So Millets, they are saying that we are at the stage of charge, we have to frame the charge, accused is delaying the whole process. Now which statement is correct of the CBI, I don't know.
My lord, that is a different chapter, lordship. Now this case cannot be related to that case, lordship.
Well, I don't know how this objection is.
No, lordship.
Same accused, same trial, same
that
FIR.
Petition has been filed
Before one bench, they are
Recently,
saying it is a stage of
2024
investigation.
They have filed the petition. Now at the start, therefore, it is the stage of consideration of charge, lordship. Your lordship has handled the first date of that application has been moved before this honorable court. Regarding that appointment of PP, lordship, they have challenged whether there is a director of prosecution is there or not.
No, the issue is that whether the PP of the CBI is PP or not.
That is the issue there.
I am
It is
saying
not here.
before one
that
bench,
petition has been filed in 2024, lordship.
Allow me. Millets, with due respect, I am saying before one bench, the CBI is saying that the matter is at the stage of investigation, which can be correct because they are asking for voice sample. They will have to voice a spectrometry done, compare both the samples, and then come to a conclusion, then submit the supplementary charge sheet to the trial court. So here they are right that matter is still at the stage of investigation. But before another bench, they are saying matter is at stage of charge. They want to frame the charge, matter is listed for tomorrow. And we are contesting. We are saying it is not a stage of charge. So Millets, I am ignoring that. My learned brother Millets, I will request to kindly, charge sheet. Millets, kindly come to the charge sheet, Millets. I am answering all his objections, Millets. He was making a case of public emergency, Millets. Though it was not pleaded, but this court can always consider whether there is a public emergency or not. Millets, kindly take up the charge sheet, Millets, that page 18, para 31. That table, Millets. Para 31 Millets. Millets, admittedly, the FIR in this case was registered at 9:40 p.m. That is in the evening, early night. It is recorded in the FIR, so it is their document. On 11th of April 2018 Millets. They are saying it is a trap case. I accept it for the sake of argument. They are saying source information. Meaning thereby, somewhere during the day on 11th, they got some source information, which of course they will not disclose. That also agreed. Evidence Act permits them not to disclose their source. Millets can come to this table, what they are doing. And this table they have relied, so I am referring. Millets, the first phone number at the top is of Mr. Ramesh Goenka, one of the accused. The permission given by the Home Secretary is 23rd February 2018. They got the information, my lord, that is their argument, on 11th of April 2018. And they had already used that information to get the permission from the Home Secretary on 23rd of February. They had some Jyotishis telling them that after 2 months, Mr. Goenka will do some mischief. So take the permission of the Home Secretary in advance. And Home Secretary needs to explain how something which is going to happen after 2 months, he takes cognizance of that and grants them a statutory permission. It is 23rd February 2018 Millets. That is the first thing. Then Millets, on the right side, this is the permission given by Shri Alok Kumar Verma, Shwetab Suman, which I am. Millets, this date is 6th of, I'm sorry.
It's
9th April. Millets. Again, now I'm not repeating what I'm saying for Mr. Goenka, that they had a premonition that some crime will be committed in future. So they were taking all the precautionary measures. Millets, on 9th they knew that I as a public servant is committing some mischief. They went to their director, took a permission. 9th, no, this is 6th of April, I'm sorry, Millets. So on 6th of April, they were aware that me as a public servant is committing a mischief, criminal mischief. I'm trying to violate the Prevention of Corruption Act and extort a bribe for me. Because they have already taken permission from their director. Then Millets, the 4th number on the left side, that is the permission given by the Home Secretary, is again another number of Shwetab Suman. This permission is given on 9th of April. Millets, if they can take the approval of the Home Secretary on 9th of April for one number, they can take the permission of the Home Secretary on 9th of April for any other number. What emergency they are talking about, that there was an emergency, that's why they have rushed to their director. The whole thing is a concoction subsequent to the entire incident. That's why 3 dates of arrest. That's why 3 places of arrest. That's why 3 times of arrest. Now, Millard, in a trap case cannot be led without there being a public servant. Because the jurisdiction of CBI will not come into operation if there is no offence under PC Act. For an offence under PC Act, there has to be a public servant. Either I am, as a public servant, party to the offence, or somebody is committing some mischief in my name. So there is a public servant. There are 2 out of 7 accused, 2 are public servants, Millard. Shwetab Suman and Pratap Das. Trap is an extraordinary situation. It is an exception to 17A's requirement of sanction also of the PC Act. On 9th, they are aware some mischief is going to be committed. Rather, they are aware on 23rd February. So why did not take, when they took the permission from the Home Secretary on 23rd February 2018 for Mr. Ramesh Goenka, he is not a public servant. The jurisdiction could have been triggered only when the allegation is Mr. Goenka is in hobnobbing with Mr. Shwetab Suman or Mr. Pratap Das. Why did not they take permission for others? The public servants. So where is the emergency? There is no emergency. They have dressed up their record because they are internal, these are their internal records. And Millets, So, Millets, they are saying that we are not challenging the legality of the intersection. Millets, we are contesting. That's why we are insisting. I came to this honorable court by way of writ petition criminal number 4 of 2023, titled Shwetab Suman versus CBI. This honorable court accepted their undertaking that they will provide me all these interception records. Matter was remanded back to the trial court. There they resigned. They said they will not provide. They are withholding this information because then the moment I get this information, these records, the whole case will collapse. Because they have dressed up their records. They are not giving me records. They are contesting. I'm in the process of invoking the jurisdiction of this honorable court regarding that also. So, Millets, to say that we are not challenging is factually incorrect. There is a process under the CRPC. We are contesting that before the trial court. We have to first see the records, only then we can contest. Without having the record, I cannot invoke the jurisdiction of any higher court to say that you please quash it. What is to be quashed? The court must be shown. So therefore, Millets, this argument of the CBI that they should first contest the legality and then only refuse to give the voice sample is not correct. We are contesting. Since they are not giving us the record, despite the direction by this honorable court, despite giving an undertaking to this honorable court, taking shelter of some hyper technicalities, that's why we are not able to move a formal challenge. And we are trying to collect it. Now, Millets, the issue is very simple. That have you intercepted the telegraph lawfully? The answer is no. Your explanation that there was an emergency is incorrect. You were intercepting, with the permission of the Home Secretary, the phone of one of the accused, Mr. Goenka, from 23rd of February. And permission, one interception is valid only for 60 days. So meaning thereby, Miller, that interception was coming to an end on 23rd of April or 22nd of April. So Millets, they were aware as early as 23rd of April, Home Secretary was made aware as early as 23rd of April that some mischief is going to be committed. So there is no element of any emergency, Millets. So public emergency is ruled out. Now, Millets, in this table only, the next number is again Swetab Suman. Permission is granted by the Home Secretary on 13/4/2018. Millets, I have filed arrest memo in this court, issued at the CBI office Delhi. There is no trap case. I was at my home in Noida. I was abducted from my home in Noida, taken to CBI office Delhi. Noida is a separate session unit, Millets.
Yes, that part we have already
Yes, Millets. So here I am only using it. The permission which is given on 13th of April, I am in their custody since 12th evening. Who is giving me phone to talk and demand money? Because I am in their custody since 12th evening or afternoon. They kept me for whole night in CBI office, Delhi, on 12th and 13th intervening night. On 13th they got the permission, they started recording or intercepting my phone. No issue. So that means in their custody I was talking on phone to Mr. Goenka and demanding money. I mean, what kind of argument is this? I leave it to the Honorable Court. So, Millets, coming to that, now coming to the factual matrix, Millets. My learned sister has pointed out that Mr. Suresh Agrawal, who should have been either a victim or a perpetrator. Section 24 of the PC Act was in operation at that point of time. So, in April 2018, Millets, Section 24 gave an option for Mr. Goenka either to be a victim or to be a perpetrator. He could be either of the two. CBI has chosen to make him a perpetrator. Now 24 has been repealed by the 2018 Amendment Act, that is 26 July 2018 onwards. So Millets, bribe giver can only be a perpetrator. Earlier bribe giver was both victim and perpetrator. Millets, there is not a single, what my brother has said is theoretically correct. That you can intercept one number, one telegraph, and record the voice at both the ends. I am talking to somebody, my line is being intercepted. So the person at the other end, whether he is the maker of the call or receiver of the call, his voice also be intercepted. That is correct, Millets. But can he show me one word in the charge sheet? Charge sheet is before my lords. That the voice of Mr. Suresh Agrawal is also on their tape. The voice of Mr. Suresh Agrawal is not on their tape. It's a question of fact. And that's why there is no statement. What they have incorporated in the charge sheet, it is between Mr. Swetab Suman and Mr. Goenka. Nowhere, Millets, voice of Mr. Suresh Agarwal, the alleged bribe giver, is on the tape. They have not shown it. They are not saying in the charge sheet, so they can't improve their charge sheet now. So, Millets, with due respect, the Constitution Bench judgment of the Honorable Apex Court in the case of Neeraj Datta versus the State of Delhi, which is a binding precedent for all of us, my lords included, demolishes their entire case. There is no demand. There has to be a demand from the public, the person who is the victim. Mr. Goenka is only a facilitator. He is not the victim. I mean, assuming what they are saying is correct in that case. The victim is Mr. Suresh Agarwal. There should be a positive demand both for Section 7 and 13(1)(d), which has been pressed against Mr. Shwetabh Suman, my client. Otherwise, there are n number of judgments, including in the case of Neeraj Datta, who was convicted by the trial court, upheld by the Honorable Delhi High Court, and it was set aside by the Honorable Supreme Court because the prosecution could not show that Neeraj Datta, Mrs. Neeraj Datta, she was an employee of MCD of Delhi, she has made a demand. So here in this case, there has to be a demand either by the public servant, that is 7 and 13(1)(d), or somebody on behalf of public servant, whether impersonating or acting with collusion or consent, to make a demand from Mr. Suresh Agarwal. That demand is not there. There is not a whisper in the entire charge sheet that Mr. Suresh Agarwal was approached by A, B, C, D, anybody, and asked to give some money. The story is there. But who asked? When was Mr. Agarwal asked? In fact, when this alleged trap was let down, Mr. Agarwal was not even in the country. That explains the missing link. And that's why this dressing up. Mr. Suresh Agarwal was not talking to anybody. Merely because certain amount is discovered from the residence of a senior advocate of this honorable court, the crime of demand of public bribe, whether under Section 7 or 13(1)(d) of the PC Act, cannot be said to have been committed. Even if the money is, let us say, black money, that is the tax evaded, it will not come under the PC Act. It will only be a misconduct under the Income Tax Act. That also will have to be determined. And they are nobody to say ask from where Mr. Goenka got that 40 lakhs of it. So, Millett, on merit also they have no case. It is not that public, we are asking something which is in the face of the public interest. We are only asking that as a citizen of this country, we are entitled to the lawful protection of law. We are entitled to ask from this honorable court that an investigating agency must be required, must be compelled to comply with the mandatory provisions of law, and which they have not done. So, having said that, Millett, there is no case of any demand in the entire charge sheet made from Mr. Suresh Agarwal. The only conversation which is reproduced by them in the charge sheet from para 33 onwards, Millett can just refer to the charge sheet, I'm sorry, Millett. So, para 33, page 20, Millett, internal page 19. This is the conversation between Shwetabh Suman and Ramesh Goenka. Next is again Shwetabh Suman and Ramesh Goenka. Shwetabh Suman, Ramesh Goenka. Shwetabh Suman, Ramesh Goenka, Millett. And Pratap Das. Pratap Das and Shwetabh Suman. So, Millett, there is not a single word spoken by Mr. Suresh Agarwal with either of the public servant or the alleged facilitator. That's why his phone was not. They were working on this case since at least 23rd February 2018. Meaning thereby, Mr. Ramesh Goenka's phone was under surveillance from that day onwards. Unless they come out with a story that they chose not to intercept, though they had permission. So, Millett, Mr. Ramesh Goenka must have talked to n number of persons. As an advocate, he must be speaking to his clients. Now, Millett, I am also raising a potent legal issue. Millett. Why they have not intercepted Mr. Suresh Agarwal? Millett, there is a legal vacuum. The Evidence Act, Section 126 Evidence Act, and the Telegraph Act. Evidence Act says that any communication between an advocate and his client is privileged. It will not be proved in a court of law. They deliberately and willfully did not touch Mr. Suresh Agrawal. They had intercepted his phone, illegally of course. But they are not admitting in the charge sheet, Millard, because that would have been immediately hit by the bar of Evidence Act. Now, Millard, the problem is Section 5 of the Telegraph Act makes no reference to advocate-client conversation. But for this issue, Millard, Telegraph Act or Information Technology Act will become the general law because they deal with a general situation, interception or decryption of the telegraph. And Section 126 Evidence Act will become the special law. So it is settled right that a special law will prevail. Meaning thereby, Millard, any communication between me as an advocate and my client cannot be touched by them. That's why they have taken the precaution to exclude Mr. Suresh Agrawal. But since they have illegal tapping of Mr. Suresh Agrawal's phone, they want his voice sample. Initially, they did not make him a party in the first revision. They did not ask for his voice sample before the trial court. Now they have made a party to him so that they can use and say that even if we illegally collected, which is the last legal issue which I will raise before my lords this case. So, Millets, Mr. Goenka's conversation with Mr. Suresh Agrawal cannot be proved in the court of law. There is no exception made to that. It's very clear. In that case, unless they prove that Mr. Goenka or Mr. Pratap Suman or Mr. Pratap Das asked for bribe from Mr. Suresh Agrawal, this case cannot proceed further. So, Millets, to evade and avoid this bar of law, which is non-negotiable, inalienable, between an advocate and his client, I can speak to my client for anything. My client can tell me in confidence anything. If they cannot disclose their source, I as an advocate can also not disclose what my client has told, even to the court. I am protected, Millard. My lord knows it. I don't need to waste time for this. So, Millard, I am saying that on merit also they have no case. Now, Millard, one last issue, though my brother has not pleaded, but as a responsible officer of this honorable court, it's my duty to invite my lord's attention. Give me the judgment. Never. This is my. Millets, there is the old judgment way back 1973. It was an income tax case, Puranmal versus Director of Inspection. It's a constitution bench judgment, Millets. A view was taken by the Honorable Apex Court that illegality of collection of evidence, method of collecting the evidence, will have no bearing on the evidence itself. So, even if they are not pleading, Millets, for the sake of fair assistance to this honorable court, I am inviting my lord's attention to this issue. Millet, subsequently, on the interpretation of this, difference of opinion arose between various division benches of the Honorable Apex Court. And matter was again sent to another constitutional bench. That is, Millets, the case number 3, State of Punjab versus Baldev Singh, page 29 onwards, Millets. Millets, it is a 5-judge bench. Justice Anand, who was the Honorable Chief Justice at that time, page 29, Millets. So, Honorable Justice Anand, the Chief Justice of India at that time, he has written the judgment, and I will just skip the Millets. Can start page 50 onwards, Millets. The second paragraph from the top, Millets. The last submission of the learned counsel for the respondents is that even if the search and seizure of the contraband, the judgment is in respect of NDPS, Millets. So it is a criminal case. So this will apply to, because NDPS is also a criminal law and special act. PC Act is also a criminal law, a special act, while income tax is not a criminal law, millet. So it says, contrary to the provisions of Section 50 of the NDPS Act, it would still not affect the conviction because the seized article could be used as evidence of the unlawful possession of a concerned so and so. So, minutes, it's very elaborate. I am leaving it from page 50 onwards. It is required. In my synopsis, I will refer the material paras quoted. So, finally, minutes, the court has arrived at the conclusion, which is on page 56 minutes, internal page 28. I am reading last line minutes. An illegal search cannot entitle the prosecution to raise a presumption under Section 54 of the NDPS Act, which is here under Section 20 of the PC Act, that the judgment in Puranmal's case cannot be understood to have laid down that an illicit article seized, here intercepted, during a search of a person on prior information conducted in violation of the provision of the Section 50 of the Act can by itself be used as evidence of unlawful possession of the illicit article on the person from whom the contraband has been seized during the illegal search. That the judgment in Ali Mustafa's case, correctly interpreted, in Ali Mustafa they said that Puranmal will apply only to the income tax cases, not to the criminal cases. Distinguish the judgment in Puranmal's case and the broad observations made in Prithvi Chand's case and Jasbir Singh's case are not in tune with the correct exposition of law as laid down in Puranmal's case. The above conclusions are not a summary of our judgment and have to be read and considered in the light of entire discussion contained in this thing. We accordingly answer the reference in the manner aforesaid. 2 minutes. Very categorically, the Honorable Supreme Court said that if you are collecting an evidence illegally, then you cannot use it against a person for securing the conviction. And there is a reason, my lord, to distinguish an income tax proceeding and a proceeding under CRPC. My lord, in income tax proceeding, the facts of the Puranmal's case were the facts in Puranmal's case were that any search under the Income Tax Act took place. Income Tax Appellate Tribunal set aside the search, that is, quashed the search warrant. Matter kept lingering and finally reached the Supreme Court. The contention of Mr. Puranmal, who was the person who was searched by the Income Tax Department, was that once this search is illegal, in that case, you cannot use the material which you have collected from him. What Income Tax Department did, they used those documents, framed an assessment and demanded tax. Unlike in this case, Millets, and there is a finding by the Supreme Court in this judgment, Puranmal itself, Millets. It is on finding in Puranmal Millet that the search was not illegal. So, the finding of the lower authority, lower court, stood reversed. That has also been noted in this case, Millet. So, in the case of income tax search, Millet, the assessing officer conducts an inquiry. He has to share entire material in his possession on which he wants to rely to frame an assessment. Meaning thereby, Millet, whatever was seized from Mr. Puranmal was to be shared by the assessing officer in the course of income tax inquiry and give him an opportunity to rebut. Here in this case, they are not ready to share it even after order of this honorable court.
Lordship, by objection, Lordship, this court never gave such order to give any such document to them, Lordship. The order which was passed is that they have filed a writ petition, Lordship. Against, in that writ petition, we have submitted, Lordship, written objection, Lordship. Inadvertently, we have said the relied upon document has been, we have no objection with regard to the submission of the giving of the relied upon document to them. That is our submission. However, Lordship, while in the passing of the order, that has not been cited, whereas it was written that the PPA submitted no objection. If that be so, Lordship, then in the last paragraph of the order, suppose, Lordship, tomorrow any accused come before this honorable court with an application that we need bail, and if a PP starts arguing that we have no objection, whether this honorable court will state that no, even in spite of the fact that PP has no objection, don't give him bail. That will be not like that, Lordship. The moment PP will raise and give no objection, court will never say that no, don't give bail. Give him bail. But here in this case, Lordship, they have filed a petition, we have objection. If your Lordship call for the record of those case, your Lordship will find we have submitted written objection. However, on the last date of the submission of the taking of this case, Lordship, I have submitted the relied upon document. Because some relied upon documents has also been not given to them, Lordship. Therefore, I have submitted, Lordship, the relied upon document may be given to them. That was my submission. And in the order, in the last paragraph, it was reflected that let the trial court dispose of a petition. They have referred a petition before the trial court for giving of those documents. Therefore, they has to be disposed of in accordance with law. That was the observation. So now they cannot say that no, this honorable court has given a direction to give the document. No such order has been passed. Why? I don't know why it's a misleading submission given by my.
Let's say I'm not misleading. My brother is probably making something, some uncharitable remark against me. I have never misled
no,
any court.
Lordship. If your Lordship may kindly have a look, I will give the order, Lordship. May I have a look into the order?
I'm stating, let's, in that case, this honorable court, just like their earlier revision, recorded their undertaking. Now they are saying that they only meant this, not that. But judicial dicta is very much there that the CBI has no objection to providing these records which are recorded, and those are the records of the telephone tapping. If there was an error in the record, they could have come back to this court that there is an error, please rectify.
By the time we come to the point, Lordship, already the Lordship who has passed the order, he got retired.
There is nothing.
There's a bar.
There is no bar that if the honorable judge retires, other judge cannot.
That apart, Lordship, that has not caused any harm to CBI.
That is not the jurisdiction stood ousted.
That apart, that order has not caused any harm to CBI, Lordship. It is very clear that as part of the procedure of law, you pass the order, dispose of the petition which has been relied upon by the petitioner. No harm. So why should we unnecessarily why shall we go for a modification?
That is not the issue. I don't want to consume precious judicial time.
No, you are making such submission before this court.
No. That I stand by that. I stand by that we will deal with in other proceeding. But the limited issue is, what I was trying to explain to my lordship, that in income tax inquiry, there is both investigation and inquiry under income tax law. But after investigation and inquiry takes place, in the course of inquiry, whatever is collected, that is to be provided. The system is, income tax rules are very clear. That has been upheld in Puranmal also, Rule 1112. What happens is, the person is allowed to take the photocopies and then prepare his defense. Here the problem is, the CBI has a practice of not sharing the authorization for telephone tapping. Though that also is incorrect. I have filed the documents of a CBI court, Ghaziabad, where they have produced those things along with the charge sheet. So they decide in which case, pick and choose, which again in violation of Article 14, Article 21. So let's hear the problem is, why the Honorable Apex Court has made a distinction between a proceeding covered by the Puranmal and a proceeding under the criminal law. That I am trying to explain, because there is a very valid reason. No prejudice will be caused to a person even if the income tax search is illegal, because he will get a chance to rebut the material which was collected from him. Because he will be allowed to take copy and he will be allowed to rebut it before the learned assessing officer. Here in this case, accused will never get a chance to rebut. That is the whole problem, and that causes my life and liberty is going to be taken away without giving me any chance, much less fairer chance, to show to the learned trial court or any other court of higher authority that this telephone tapping is ab initio illegal. So primarily, Millets, the entire matter is illegal. It's without any basis. There is no person from whom any bribe has been demanded, and that's why his phone has not been tapped or is not being included. So my respectful submission, Millets, both on the facts as well as the grounds of law, this revision petition is bad in law and it deserves to be quashed with reasonable cost. Much obliged. And Millets, within 2 days I will submit my detailed synopsis if my Lord's promise. Much obliged. I will be pleased.
I just want to point out one thing, Lordship. My learned friend has made his argument on facts, whether this court will entertain such facts or not. It's a trial court which will decide the matter on the matter of fact. And lastly, Lordship, the phone regarding the involvement of this Suresh Kumar Agarwal. Lordship may kindly have a look in same para, down below, para 32. In para 32, it was reflected. Para 32, we will look into where we have said the transcription of the voice file is available in 2 numbers, DVD IO copy and IO copy number 2, received from CBI. So were prepared in consultation with the witness, and after listening to the voice files of the mobile calls and also going through the transcript, the voice were identified by witness to be that of accused persons, namely Shwetak Suman, Pradeep Das, Ramesh Goenka, Amit Goenka, Suresh Kumar Agarwal is here, Lordship.
My Lords, there is a difference. Voice
Those difference cannot be taken up by this court
basic
now.
criminal law.
That
My
those-
brother should allow me to say one
Lordship,
line.
those points cannot be taken up by this court now. This is
Well,
not an
let's-
argument on the point of charge, Lordship.
No,
We are
Millets.
on a different footing,
With due
Lordship.
respect, in this case, it is material. What is available with them is not evidence. What is produced before the trial court is evidence. That too, after that is proved. So they have not produced any voice sample file of Mr. Suresh Agarwal before the trial court. They might be keeping n number of things in their godowns.
Lordship, one more thing, Lordship. One more thing my learned friend has shown, that that on 9/4/19, in the same chart, Lordship, in the same chart in the chart sheet, is chart, they've shown that on 9/4/18, the mobile number has been intercepted. On 13, we have not intercepted. He is on custody from 12. On 13, that order which has been passed by the director of CBI has been ratified. It's a completely misrepresentation of the
Millets,
fact,
again,
Lordship.
my brother is using very harsh words against
This
me.
is-
He
this
should
is-
at least
no,
consider
no,
my
no,
age.
you see.
I'm not
No, no, you
misleading
see,
Millets.
this is the order.
Millets, kindly.
We are not saying that intercepted. Permission.
No, my lord,
Lordship
kindly
may
allow me. Give me 1 minute.
Lordship may kindly-
1 minute, 1 minute.
Please, let me submit.
No, 1 minute. You have
I am
made a
giving
very
my
serious
reply.
allegation against
I am
me.
giving a reply. Please.
No, please.
Please.
No,
Lordship may
please.
kindly have a
Millets,
look
it
into
is the permission given by
Lordship
Sri
may kindly-
Rajiv Gauba, Union Home Secretary, not ratification. It is
Lordship
their
may-
document. Permission word is used.
Yes.
Now he is improving it by saying
Whatever, Lordship,
ratification.
permission. It's a
It is a permission given on 13th of April when I am in their custody since 12th of April.
Permission is not an interception, Lordship. Permission. We are not intercepted.
So
on
that is
13th.
what I am saying. You were permitted on 13th and you intercepted my phone from 11th. According to you.
On 11, already your order is there. This is the order from 6.
No, that is illegal.
Six.
There is no emergency.
That is your stand.
You are aware since 23rd
No.
February that I am committing a
That
mischief.
is your stand.
That is my stand.
Yes. Our
Let
stand is
the
illegal
Honorable
also.
Court consider it.
Yes.
So, Millard, with due respect, it is the permission given, not the ratification. Otherwise, they could have written ratification, which they are using now.
Mayor using of a separate word will not.
I am using your word. I am using the word of
The
CBI.
entire order illegal, Lordship. It's a word which has been used by IO. It will not made the order illegal, Lordship, which was passed by the competent
Millard,
authority.
in that case, I have a small request. Let them produce their records. I
No,
will
this is not
assess.
a forum.
Everything
to
is
produce-
illegal.
This is not a forum to produce any.
That's why you are
record.
running away.
No,
This is
no,
a
no.
higher forum.
No. Why are you are running away from the giving voice sample, Lordship?
It's my right. Millets, with due respect, CRPC permits Honorable High Court to act as a trial court. It's not that there is any legal bar. My brother should know. So, anyway, Millets, much obliged, Millets.
May I permit to say only one line? They are again and again saying that was the Home Secretary's order, which was given from the retrospective effect, has ratified the order of Director, my lord. My lord, your lordship, I have pointed out that to my lord. That ratification, nothing is there in the order. that the order of the Home Secretary is ratifying the order passed earlier by the director. Nothing is there. That argument I have made, I am just clarifying it.
And that means Home Secretary is not saying that I am ratifying. It may be a general order that I am permitting the interception of the phone. When somebody is ratifying, I'm not assuming this Honorable Court ratifies the order of the lower court. Court will specifically say that such and such order is hereby confirmed.
Very endless argument.
कोई बात नहीं.
अभी हम आपको having the privilege.
Affidavit in a sense for the condonation.
Condonation we have already filed.
We have not received till date, till now.
What can be done, Lordship, in that case? With regard to the argument has concluded only on the point of condonation of delay. They have concluded their argument on.
But whatever that if they file, suppose that
Lordship, let me send my juniors to that filing section. I'll send. Lordship may kindly give a note. Slip, Lordship. It will do, Lordship. Lordship may kindly direct to give a slip. We'll give it in the filing and can be brought on record. Have a slip on there.
Wants to file written objection.
Yes.
Against your application, but the rest I don't know whether any other councillor also going to file any written objection against the for condonation.
Respondent number 1, Lordship, we will not file Lordship written objection,
We will
but
file
we will file
oral
submission.
I will take a legal ground on this issue because 397(3) is very categorical that there cannot be a second revision. What they did it very cleverly. After withdrawing the first revision, this point I have argued.
Lordship already argued it will be a continuous process. You will again make, Lordship may kindly.
No, I'm just saying, I will write it in my synopsis minutes, I will clarify. I'm not claiming simplicity, but I'm claiming different.
May I please your Lordship?
Mr. L understanding of the people subject by that he has got five interrogatory for condonation. That regard Mr. T. Google demanded what the payment of the
Item number
the on the other partner is raised back regarding body on the demand to be according to this. Can it be listed? We cannot give any date now, but because this in regards to item number 2, there should be a date.
Yes, on the point of the delay. Otherwise, they have concluded their argument.
Yes.
And the law point involved same. My submission will be same, Lordship. The only difference is that in this case, Lordship, initially there is a order from the director of CBI, and it got ratified from the secretary. There, it is direct. There is a direct order from the.
But whatever, it will remain as part heard now.
Yes.
That limitation point may be heard, and along with if any reply and some is this will be there.
Lordship.
But question is that when to pay? Do you want any?
Let it be on third of this month. June.
I will not be.
Then when your Lordship will be available?
Because 18th of June already lots of matter has been fixed.
Lordship.
I may join this bench by 18th, but 18th is already fixed number of cases. 18th may not be possible.
When your Lordship will be available?
This time, 20th of June, 20.
28th of June?
20. 20 is a hearing day, I think.
20 is a hearing day, Lordship.
It's a Thursday.
Already one case is fixed. It's a very voluminous case. Hogendra Sakma, Lordship, that 8 volume of paper book is available. I mean to say there. Let it be on
In that case, it had be 25th of June.
5th of June. Yes.
25th.
25th.
Not 5th. 5th I will not be here.
Lordship, let it be even then.
Will it be convenient for you on 25th of June?
Last week I have a very heavy schedule. I will before Patna High Court, then Orissa High Court, then Bombay High Court. So only after the first week of July I can prepare time. So if I not accommodate, I will be grateful. First week of June, of course, but since my lots are not available, so that in that case, first week of July, another
holidays. We have holidays up to.
So in that case, I'm just up to.
You have already enjoyed your holiday now.
Let us also
the
enjoy.
difficulty is various High Court, Delhi High Court is still open today. They are closing from Monday, first of on what they will go up to July, first of July. Supreme Court already closed. It will open on 8th of July.
Yes.
Patna High Court closed much earlier. Orissa High Court closed. Chhattisgarh High Court closed much earlier. Various High Courts have their own set of this thing. So that's why advocates do not get a chance to enjoy a holiday. We have to keep rushing. So, I'm just.
Otherwise, I could have given 25th will be the whole hearing day also. If you
24th, I am before Chhattisgarh High Court. I will return again. I have given it's a bail matter in Patna High Court, PMLA bail.
Then it will not be possible. Then 26th is Wednesday, 27th can be, or otherwise it has to be the 3rd week of July.
Well, I have no difficulty 3rd week of July, subject to my Lord's convenience and my other colleague.
Because one matter has already been.
Let it be on then on 20. 20, I will.
20.
20, Lordship. Let it be on 20, Lordship. Somehow I will manage your.
Okay.
20.
Because I have already done my part.
Because I have to rush to a heavy partner matter in Patna High Court on 21st.
Lordship, my learned friend has already concluded his argument. My learned friend has already concluded his argument. There,
No.
Let me
some issue.
There is no other issue. If you continue, then it will continue for another 1-2 months. So he has already concluded his argument in respect of item number 3. And Lordship, his junior is quite available here. He will be here. And on the point of only delay, that matter may be heard, Lordship. No further argument.
Could it be 19th?
19th?
June.
19th of
June? One day postponement. 19th I will.
19th is a Wednesday.
Wednesday.
Somehow it may be.
I subject to my Lord's convenience.
It is not a hearing date, but I don't know if it has to be.
19th I will come in because 21st I have to be in Patna High Court.
It's a Wednesday.
And it's a CBI case only, so there also my counterpart is as competent as my learned brother.
Lordship, my only submission is that his part is over and item number 3 is completed.
No.
He has no further argument, I think. He has already made his argument on every pros and cons has been filled up by him.
See, law points are
already covered.
Law point will arise after the argument.
It will continue.
Law point, quad delay. There are both kinds of judgment by Supreme Court.
Delay is not, he is not affected by delay, Lordship. He has no right to make a submission on his other case, Lordship. He has no right.
No, I have a right.
How can it be? You have right?
Number 2, you are not.
He is not a party.
Not I am also raising this delay on a different ground.
So he cannot. I don't know how he
No,
makes
which item you are saying? This item number 3.
Item number 2 I am not.
CV.
No, I am not. Item number 2 I am not. We are only in item number 3.
You again want to argue on item number 3?
No. I'm giving
Then it's over.
Then it's over.
It's
If
over.
reserving, then it's over.
Okay.
Why not may reserve item number 3?
Item number 3, we have.
Oh,
Judgment is reserved.
with that-
Judgment is reserved.
Yeah, but as far as
Next time you can file your synopsis of the argument.
within
that
2
will
days.
be included.
So, as far as we are concerned, my lords have reserved the judgment.
Yes.
Something may happen in item number 2 depending on their
Nothing will happen. I have concluded my argument. Only on point of delay, it is up to the
I told him in the break not to get emotional.
No, I am not emotional. I am making my
Arguments
submission.
are, once the
I
arguments are
never
over,
get
we are back
emotional.
to our brotherhood.
My submission is like that. What can I do?
So 20 is a Thursday. Can it be picked on 20th?
Yes. Already one voluminous matter is there. Even then, Lordship, I'll manage. Somehow I'll manage on the point of only.
Item 2, Lordship, my senior will argue, and 25 it will be better because in 25, item 2, regarding item 2, Lordship.
Regarding item 2 only. I'm
कहाँ है सर?
Item 2, lesson number 1.
कौन advocate तुम्हारे senior?
As board. On 20 is the difficulty, Lordship. 25 will be better.
Okay, then let it be little bit of 20. 25th of, sorry, June. Okay, then it will be fixed on 25th of June, and other it will be order is reserved. So
I have one thing to say. My brother has already said about the Mr. Suresh Kumar Goelka. I am thankful to him. But with regard to Pranjal, Pranjal is also in the same position. His conversation is not there. Even in the conversation, his name is not there with regard to Pranjal.
Okay.
Highly
Meeting was there. Right.
Sir, will you come to court again? Not because the court is ready. Yes. Only for you. Yes, sir.
I please, Your Lordship. Lordship, my senior is not well, Lordship. Someone expired, Lordship. Kindly fix it on Tuesday, Lordship.
Your senior who is?
SG Borwa, Lordship.
SG Borwa.
SG Borwa. Kindly fix the matter on Tuesday, Lordship. Yes, there is urgency in this matter, Lordship. No interim order is there, Lordship. Otherwise, respondent has appeared today, Lordship.
DV Act case, you know, domestic violence.
DV.
So we are formal. He is respondent.
You have already.
And since there is no interim order, Your Lordship may.
Can it be Tuesday?
Can on Tuesday.
List to like Chadika.
No, my Lord. List was not.
Tuesday is the which day? Fourth. Fourth, most probably one matter is there, I think. No? One matter I have fixed. That matter is fixed on 4th. It will be a.
6th, Lordship.
Then it should be 6th on.
6th, Lordship.
6th.
6th. Possibly.
Oh.
We appear for the first time. Respondent.
Respondent.
I am for one.
Yes. Yep.
My Lord, in this case, similar pair, Lordship. Can it be on 6th, Lordship?
Oh, here also Tuesday.
Senior as you right.
At the request with the
On 6th of June.
6th.
Possibly.
That's got to item number 30 to 14. Would it be possible to complete the argument?
There are conviction of 5 years under section 307, and there are 3 appeals against the same judgment.
Mane 3 convict has preferred 3 appeals.
5 conviction. 5 accused represented, but there are 3 appeals. 3 appeal.
3 appeal.
So probably Mr. Chaudhary. All right, my Lord. Actually, even if I complete my part, but other 2 will remain. But judgment same
So
judgment.
in all the matters you are representing?
No. I am representing only one. I am only 13.
He is on 13.
You are on for 13 only.
Only 13. In 13.
And 14 Mr. and the is there.
And
NNB
Chaudhary is there.
Oh, NNB Chaudhary.
And another is my Lord, Mr. BM Chaudhary is there.
Miss B. Chaudhary. Miss B. Chaudhary.
Adjournment in some other matter. He is available or not, I don't know. BM Chaudhary. Whether he is
This is BM
now.
Chaudhary. B. Chaudhary. Miss B. Chaudhary.
No, I'm very. Montana.
Miss B. Chaudhary দেখাইছে দেখুন।
No, B. Chaudhary was junior. So let some other.
Let it be on next week. Old matter we
All
cannot
these
assume.
are the old matters of
No, yes.
2011.
But today, after giving so much hearing, my Lord, I understand your Lordship's burden.
Even I complete my case, then the other 2 will remain.
And others are also not there.
But your submission and the submission of the others, your submission may cover the submission of the.
No, my Lord.
Eh?
No, my Lord. Actually, my Lord, 34 is there. Others only one blow. So if 34 goes, then one has to go. One has to go to jail, my Lord. One has to go. Because they concrete evidence against him. But against my Lord, others, that's why, my Lord, there's a conflicting argument.
Okay.
So that is the problem, my Lord. Otherwise, it will cover, my Lord. So far as 325 is concerned,
34 is the main culprit, I think.
yes, my lord, 34, my lord. And the day of, my lord, that Lohomi and Bhaswani days, my lord, there is in Pandughat, there is a clash between among the friends. So that is the case.
But the case is convicted under 307 only.
307, 325 also there.
325. Any such kind of injury on the vital part of the body?
And that is there is a injury on the head, my lord. Injury on the head. But who has given that blow, my lord? That is not ascertained, my lord. Medical evidence also not says which injuries gave yes. So that's why, my lord, some hearing is required.
But out of these 5, someone...
Someone has to, my lord, yes. Other will live some of, my lord, acquitted.
In the case, yes, should be a fixed date, I think, because it's the 2011.
Due to paucity of time today, my lord.
No, that will be recorded, but the question is that all are 2011 matters.
Yes.
So, should we fix any date or after 1 week?
Will it be after 1 week?
It will be after 1 week. The paucity of time to decide medical. All the time.
What I can next is it.
My lord, this case appeal against Equitel, my lord. The private respondent here, my lord, next time also.
Private respondent's name is
Yes,
shown.
madam.
Name is shown, madam.
Okay. Name 1, 3, 4, 5 advocates are there. For private respondents. How many private respondents are there?
My lord, so my lord, 2, my lord.
That means 2 accused persons.
Yes, my lord. Sorry, my lord, 3. One is Raju Datta and someone Prafullo Datta. For 98.
There is no urgency as such. Appeal against acquittal, my lord. 498. Yes.
Next week, my lord, the earlier occasion they also absent, my lord.
In earlier occasion also?
Yes, my lord. And last order, my lord, 9/3/2024.
In that case, my lord,
we're just seeing data.
Yes.
Oh, but the last occasion they were present. That is on 30th of April 2020.
My lord, 19/3/2014, my lord. That, my lord, next week, man, any day fixed next week, my lord. For this. Any lordship convenience, my lord. Yes, my lord. Not I.
Sorry?
Yes, sir.
Eight. So, names of 5 counselor estimate paper after 1. The old
she is representing respondent.
You are representing which number of respondents?
Kunjan. For respondent number kun? Tinta is there.
There are 3 respondents are there.
For learned counsel, B. Dekha.
B. Dekha. Okay. So she may not be aware of B. Dekha. Your means?
A. Das.
Respondent you cannot say that.
No. Near is not available, so
okay, your presence is always recorded. After 1.
Hello. My lord, this is also old appeal, my lord. I have seen, my lord, this is under section 377 but 376 by 511. So only attempt, my lord. 3-year conviction. Luckily, my lord, at that point of time there is no POSCO. It is a matter of 2008. So otherwise, my lord, that victim is at 18 rolls. So, my lord, it will not take much time, my lord. May I pay that, my lord? Keep it part on, and next week your lordship deliver the judgment. I'll give a little synopsis. Only on the point of sentence, my lord. 3 years, my lord. Can it be reduced? And then only 511, my lord.
Otherwise, what is the...
Otherwise, my lord, medical...
What is the term of sentence?
Sentence 3 years.
3 years.
He had 3 years imposed, my lord. He has already probably very labored, my lord. Already they are in jail for few days. I will calculate from the record. So your lordship kindly keep it part of next week. Your lordship deliver the judgment. I will be in a little synopsis, my lord. And my learned friend will, my junior, he will argue this case. Not on, my lord, because 8-year-old, my lord, girl attempt to rape, and her evidence is enough. But medically not supported, my lord. Since there is a attempt, there is not medical support, my lord. Medical evidence is quite different. There is no sign of rape, anything. But even if, my lord, we counted the statement of the victim, my lord, then I think 511 is established. So only on your lordship kindly keep it part on. Next day, any date, my lord, I will just give some 2 or 3 judgment.
3 years this year. 3 years.
No, I think. And luckily at 2008, my lord. If it is 2012, my lord, then it will be at POSCO.
Also,
very
376 by 511 would not have been there.
My lord. Then minimum 5. So that's why, my lord, actually today I thought that earlier one will be continued. That's why I have not been preparing this one. Anyway, my lord, it will not take time.
You are going to submit any written...
I will written small synopsis. I place your lordship. Your lordship kindly keep it part. My lord, and next week, any date, my lord. Even I will not be present, my junior will be doing.
Next 2 weeks...
It will not take much time.
No, next 2 weeks I'm not here. So next 2 weeks, from 18th I'll be here.
Any date, my lord, your lordship.
Hard visitor, media, council, happen. Learned senior council. And also hard visitor be done. Matter is part of accordingly. 20 we have big for it's 25. 20 can be 20
my lord.
20.
My lord.
So we remained it. I
remained the part.
Kept it as a part.
May I please your lordship? My senior, he is not available.
Mr. PM Chaudhary?
Yes. So the matter may be taken after a week. On some other day.
It's the matter after 1.
I would like.
Non-appeals, it's the matter 40. The amount non-appeals.
May I plead your lordship? Lordship, matter may fixed for next week.
Why?
My senior is personal problem.
Oh, I'll hear you only.
Yeah.
I did just make that what it happened. It's the matter of
Ma'am, that may fix.
that. Okay. That
Any date may
If the old matters automatically it will come.
It will come, na?
Automatically.
Old matter.
Because it's the old pen, it must
It
come.
is.
has already. Done application for. Same order done application for. But yeah. It's after 2. Same order. Done application for. It's a matter.
This is against and my lord in the maintenance under section 125 my lord. What I'm submitting before your lordship my lord, for the ego class of the parents my lord, 2 kids are suffering my lord. If a private respondent is my lord appearing, then it is a fit case for a reconciliation my lord. Because I have filed a suit for restitution of conjugal rights my lord. On the other hand my lord, the private respondent, this my wife my lord, she has sent a talaknama.
But you are still ready to accept her with the.
Because I have already filed a restitution petition, my lord. This is a my lord, my humble submission, my lord, fit case for a mediation, my lord. Because 2 kids are suffering, my lord.
But before mediation, not only the presence of respondent.
But private respondent is appearing, my lord. His names are showing, my lord. On other date, my lord, this matter was listed by order, my lord. But my lord, your lordship was not sitting on that day, my lord. It was on this 31. Criminal revision 487. ঠিক নাপাওঁ নতুন ল'ৰা হ'ব নেকি because respondent number 1 is represented by Council Miller. It is
Yes, obviously the name is there.
yes, my lord. On earlier occasion, Miller, it was by order listed before your lordship, Miller. On that day, your lordship was not sitting.
ফোন নাম্বাৰ আছে আজিকালি ফোন নাম্বাৰ দিয়ে নহয় কন্টেক্ট কৰা কালি পৰহি বা অহা সপ্তাহত ফিক্স কৰি লৈ হেৰি পঠাই দিলে হ'ল
fix it on Tuesday next week.
If this is a case for mediation my lord, in that case
I feel so, my lord, but I do not know what my learned friends has instructed.
ফোন নাম্বাৰটো লৈ কন্টেক্ট কৰা ফোন নাম্বাৰটো থাকিব
You are for 31?
I am
Question is that Mr. Puya is submitting that his petitioner is still ready to accept you along with the kids.
কথা বতা পাতিব পাৰি নেকি?
He has already filed.
Already married another lady also.
Oh.
Her name is Mehran Nessa or something.
There is instruction I do not have, my lord. I have to take instruction.
It's in the evidence also. Her name is Mehrun Nessa.
So in this case, in presence of the other wife, he doesn't want to come.
And in the last order of
What
the
happened
High Court,
in while I was at discharging my you as a principal judge Borkata. See, the second wife used to come to give the maintenance to the first wife. When the first wife sees the second wife, he recondition what will happen. That is there. And whenever such kind of situation is there, I ask them, they go there in the field and do whatever you like.
Then my lord,
Inside the campus. Obviously, he or she will be angry or furious. So
in one hand, my learned friend is saying that he has married a second wife. He claims that he has filed a petition for
play this matter annex.
Conjugal right.
that was
one
dismissed.
thing is also there.
That
They filed a restitution of conjugal right because to avoid giving maintenance, providing maintenance. This is one of the.
It was already dismissed, Your Lordship.
Oh, already dismissed.
Yes,
Oh, it's,
I ordered it at 7/4/21.
oh, it's already dismissed.
Title
You have any
no, instruction no, my lord. What I am submitting before lordship, I am showing my bona fide to bring back my wife, my lord. That is why I am not suppressing anything because this plaintiff is already annexed with a part of this criminal revision petition, my lord. I am not suppressing anything, my lord.
No. You have filed a restriction petition, but that has already been
For that purpose, I am not annexing, my lord. I am showing my bona fide to bring back my wife, my lord. This subsequent marriage, my lord, I do not have any instruction.
You interested that he is saying that the matter may be sent before mediation. Just you do one thing. I'm not sending you and I'm passing any order today. You just talk to your client.
Yes.
He will also talk to his client. If there is any possibility of, suppose because of sake of the kids, two kids are there. So for that their sake, if there is any possibility of say conciliation or compromise, whatever. So we are listing it just after 1 week. Take instructions from your client and people also take instructions from their client. Kids are with you, I think so.
Kids are with them, my lord. For guardianship also, I have filed a guardianship case, my lord.
That is pending, your lordship.
That is pending. That is pending.
Yes. And lordship, filed the last order dated 28/9/22. This honorable court directed the petitioner to
Yes,
pay
3,000 for payment, not paid.
Not paid.
Hard district that also for the not for hard district. You are
MR
MR Surya. Not the people for one. Not hard. Submit Mr. Pia that there is split hope for compromise and the petitioner is split the respondent. That contact Mr. Surya submitted that case from that. And however, he submitted that the petitioner has not paid any maintenance. Any trade maintenance as directed by the court by order dated 28/9. Accordingly, the petitioner is evidently complied order of court and paid the maintenance as that. However, considering matter be awarded for next after recording. How many weeks do you need? 2 weeks?
1 week will be.
One. This is an That's it.
What a date may be.
1 week post probably we don't have any such kind of date review or
after 2 weeks.
No, though. On 10th.
10th of June.
10th of
My lord. But I will take instruction, my lord, whether, my lord.
Yes, you take
Because
instruction. And regarding this, now see, there is a clear order from this court that
I'll inform the client, my lord.
3,000 has
It is not fair, my lord. I am submitting. That may be continued, my lord.
Okay.
Deeply applied.
Deeply applied.
You are on 33?
Ma'am, my lord, I'm appearing as my cousin at number 29.
29 is already...
Yes, I was on legs, your lordship. The boat crashed. I beg your pardon, my lord. Otherwise, I am prepared to do the matter. Yes, today time is also
You are appearing on item number 29.
29, your lord. I am otherwise ready with the
Oh,
matter.
you are amicus, na?
Amicus, your lord.
It's 29 hard Mr. When here, amicus. You will appear on behalf of the Okay, you are
Deeply.
not 33 is there? No. Is there any 33 thank you order? It's after 3 weeks. And now 34.
Lordship, engaged counsel is not available due to some medical emergency. Lordship may fix the matter any other day.
Mr. Das, P.K. Das.
Yes.
And you are for the private respondent?
Yes, your lordship. Lordship,
Private respondent number 2.
Yes, your
Your
lordship.
good name?
S. Hussain, your lordship.
Yes.
Lordship, can it be on 10th?
You are Mr.
M. Alam. M. Alam.
for the submitted by Mr. Arun. Mr. Yes, what do you say?
Can it be on 10th, your lord?
10th of June.
10th of May. Oh, sorry, June, sorry.
It's 10th. Okay.
Obliged.
There were around 18 or 19 numbers of hearing matters were there, but 1-2 matters the whole.
In the morning itself, a good number of cases have been mentioned.